issue may have mentioned in matter from the list you already issued. Serial number 417. It's a CMP matter will issue for restoration.
Yeah, for the petitioner.
I'm for the petitioner.
To be taken up.
From day list for judgment item 1, second appeal 380 of 2017.
There is no urgency in restoration. It will be taken up. In view of the fact that all the substantial questions of law having been answered against the applicant, the second appeal is hereby dismissed. हाँ, आ गया वो भी आई है. That is also done. फर्स्ट अपील कॉल करिए, अनाउंस कर दीजिए. आज ही जजमेंट अपलोड भी हो जाएगा. फर्स्ट अपील वाला जो सप्लीमेंट्री में है, आप है ना उसमें. सेकंड अपील वाला तो हो गया प्रोनाउंस.
सप्लीमेंट्री में
आप अभी आपका जजमेंट हो जाएगा अपलोड, आप देख लीजिए. This appeal is dismissed.
No, second appeal.
Second appeal is also dismissed.
Second appeal has been
Dismissed. First appeal court में. Second appeal को dismiss किया और कौन सा? नहीं, पहले जजमेंट करेंगे ना.
जजमेंट में सेकंड
हाँ, सेकंड अपील 380.
वो डेली में
अच्छा.
सप्लीमेंट्री में भी है.
सप्लीमेंट्री में हाँ सेकंड अपील 80 ना. हाँ लाइए दीजिए. This second appeal is dismissed. Both the second appeals which are posted for judgment today, one is SA number 80 of 2011 and SA number 380 of 2017. Both are dismissed. Clear? वो हमको लग रहा था फर्स्ट नंबर याद है.
From supplementary list for final disposal item 2, second appeal 402 of 2016 along with item 3.
कल जो आप लोग जो पेज नंबर वगैरह रेफर कर रहे थे एक जगह करके दे दीजिए. छूटना नहीं चाहिए कोई भी चीज. आप भी मैंने का बुक से रेफर कर रहे थे तो वो पेज नंबर एडिशन कौन सा है ना.
pray for my unconditional apology that I could not assist the court yesterday in this case.
Which matter?
The matter which is today. I could have assisted on the
393.
Yeah.
उसमें कुछ और सबमिशन करना.
हाँ, इसीलिए
कल हम लोग रिकॉर्ड कर दिए आर्गुमेंट्स कंक्लूडेड. क्या
नहीं, I will not propose and I will also only 2-3 paragraphs. Because Your Lordship, I also stand corrected. Yesterday, Your Lordship had posed certain queries. I must be there that one portion I had made a wrong, incorrect submission.
बताइए.
So that would be appropriate. First, I may
Yes, you tell.
be allowed to place and
पहले
then.
आप बोलेंगे, दोनों बोलेंगे कि कौन बोलेंगे?
हम चूंकि only after me if he replies it.
करना चाहते हैं कल भी हम रिक्वेस्ट थोड़ा सा समय चाहिए.
पूरी तैयारी से आया करिए कोर्ट में. कोई केस पूरा दिन सुनवाई हो रहा है तो आपके तैयारी कंप्लीट आप देखिए. इन एनी केस, राइट, वी हैव आल्सो आर्ग्यूड मेनी केसेस. You anticipate the argument of the other side, and you also anticipate the question of it. ठीक है, and then you prepare yourself.
Sometimes the question falls from the bench.
और पहली बार नहीं, ये मैटर पहली बार तो नहीं लिस्ट हुआ. Repeatedly it has been listed and repeatedly the points have been crystallized and contours of the argument has been considered. एक दिन में हम इस तरह का second appeal decide भी नहीं करते. लेकिन कोई बात नहीं. For the benefit of the law.
Both of us have had our best to
whatever,
assist.
whatever we actually we may assist are not opposed to
क्योंकि
any
बहुत सीरियस बात है ना.
हाँ.
This is a very serious proposition. कि क्या आप बताइए what
And
error
your
have you
Lordship
committed?
wanted to know what would be co-parcenary, how. Now, if the property, if we understand from the instant case itself, that would be better.
Yes.
If it is a co-parcenary, now when the co-parcenary is formed, this is very important. Now, co-parcenary does not form from Gudrugo. It only forms when he dies, leaving behind properties upon, and the sons, they succeed property from their father. Then, when they inherit a property from their father, then the son, along with his lineal descendants, they would form a co-parcenary. Not the son, along with his brothers, they would not form a co-parcenary. So the concept is absolutely clear that the co-parcenary is formed when a person inherits ancestral property and he, along with his own descendant, they all would form a co-parcenary. This is absolutely clear from the Hindu
So
law.
ancestral property would be of two nature.
Yes.
One is that the property is self-earned. Other is ancestral property of the father.
So whatever interest that particular person had, he acquires, then that interest would only be, he would have a co-parcenary along with his lineal descendant. So in the instant case, if we apply this principle,
There is a conflict.
yes,
Gudrugo,
yes,
with respect to his self-acquired property, did not have a co-parcenary along with the rest of the family members. Correct?
yes, absolutely, absolutely,
Upon his death,
yes,
his 4 sons,
yes.
they constituted a co-parcenary
No.
along with their descendants.
Descendants, yes. They, once they inherit, it is their self-acquired. It would be treated as their absolute property
That's right.
vis-a-vis their own brother.
Okay.
But once the son is born to the 4 sons, then he would have a right on the ancestral property which has been inherited by
If
his
there
father.
is already an existing son at the time of death of the Gudrugo,
Yes,
then still the property will be divided equally amongst 4, and it will not be a co-parcenary property.
yes, because the grandson does not inherit the property, has any right over the property by being grandson of Gudrugo, because it is his self-acquired property. That means it is his absolute property.
That's right.
Then it devolves on his own son. Then when it devolves on his son, then son, because he is inheriting ancestral property, that means by his father, grandfather, whatever will be the more, then if that property which he is inheriting becomes ancestral property in the hands of that.
Third generation.
Yes. And then the son along with grandson, great grandson, they
That's
all form
A co-parcenary.
being amongst themselves.
Okay.
Not,
But so far as second generation is concerned, it is not a co-parcenary.
yes, they are not. So whatever inheriting, they are inheriting. Now if we apply this in the instant case, now the 4 sons,
Yes.
they all inherit 1/4 share. First wife, second wife, we may for the time being ignore.
Subject to what he has to say.
Yes, they all, it would be treated as absolute property of their own. And then whatever property they have, that means 1/4 share, that they would, the moment their son and grandsons are born, they all acquire interest in the 1/4 share of that person.
So you are saying that there would be a notional partition at the second
Yes,
generation,
yes.
irrespective of the
Yes,
fact that
yes.
one is alive or not.
Yes,
So
absolutely.
you are saying that it will be a notional partition.
Yes, because,
But when it comes to co-parcenary property, there is a clear concept of notional partition,
yes.
right?
Now.
But when it is not a co-parcenary property, then under such circumstances, it will devolve upon them by way of survivorship.
Yes. So
By
here-
way of
Succession,
inheritance.
normal succession work,
Yes.
not by survivorship,
But by
by normal succession. So here,
no,
Your
no,
Lordship,
no, just a minute. Then under such circumstances, the second generation property being not a co-pastory property, it will devolve as if they are all tenant in common with respect to the property,
Yes.
right?
Yes.
And if they are tenant in common, and if any one of them they die prior to death of Gudu Go,
Yes.
then it will devolve only upon the remaining persons.
Yes.
But if they die after death of Gudu Go, then maybe some notional.
Because what happens in this case, now if their predeceased would go, then there is no question of their having acquired any interest.
That's right.
Because it was absolute property of Guru.
That's right.
So if it was absolute property of Guru, nothing devolved on them because they had already predeceased. So therefore, only after the death of Guru, they would inherit their share of the property. So here they have 1/4 share, and once they acquire 1/4 share, then they form a co-parcenary in their own branch. That means with the lineal descendant, they form a branch, and whatever share
They do not form a co-pastory. Their next generation would form.
they, along with their own descendants, I say that they by themselves are not
But
co-partners.
in a case where there has been no partition at the second stage,
Yes.
and partition plea for partition comes only by the third generation.
Then also, what was his interest, that has to be seen. Because again I say that your Lordship, the son of Gudrugo, their interest was not as a co-partner. Their interest was not a co-partner. They inherit directly 1/4 share. Absolutely clearly, they inherit 1/4. So, had it been a case that 4 brothers were co-partners to each other, then upon the death of one of the brothers, it would have survived upon the remaining brothers. So the co-partnery is formed only upon after they inherit 1/4, and then along with their lineal descendant they form a co-partner. So here it is a case. Then your Lordship, because I have typed it, I'll just read it. In the morning itself, a person named X who inherits a property from his father, the inherited property would be treated as his property so far as his other relations, such as his brothers, are concerned. But the moment his son and his own descendants are born, they acquire right over the said share of the property, and all the descendants of X, as the property coming into hands, their hands are ancestral property, X and all his descendants would form a co-partnery among themselves. Therefore, entire branch of X would jointly be allotted the share which X was entitled to in his father's property.
So there will be 4 co-pastories.
Four, yes,
distinct
absolutely.
co-partneries.
Yes. 4 separate branches, and they may form a co-partnery amongst themselves. They would not cross-inherit each other's branches co-partnery.
This is what you have to see.
Yes.
What they did here.
हम और 2 लाइन और 2 पैरा. A co-partnery is always formed by and started by a person who is receiving property from his father. It becomes the ancestral property in his hands, and therefore his own descendants would acquire right over the said property by birth. Therefore, entire branch of person X inheriting the property from his father is allotted the share which X would have been entitled to and would have a fluctuating interest there. So now your Lordship, here, yesterday therefore I said that I stand corrected, I have made a wrong submission. So here the 4 sons very clearly inherit only 1/4, and why this fluctuating interest would be there among the sons of Mulago, Girdhari Go, it would only be with regard to the share which Girdhari Go would have acquired on the day, upon whatever he was entitled to, and he along with his entire descendants would form a co-partnery, and their right amongst themselves would be fluctuating.
What is the consequence of death of two brothers?
It-
Full brothers of Gidhari Gop?
Yes, because they were not co-partners to each other, therefore their interest would devolve
Upon the
on
full
the
brothers.
rule, yes. That the closest, therefore on the last occasion also had pointed out that portion of Hindu law of Mitachara law which says that the closest relative would be inheriting the property. This is the whole concept of Mitachara. So closest was the full blood brother and not the half.
Okay. Essay number 402 2016 and essay number 393 of 2016. The learned counsel for the parties have jointly submitted that although the hearing with respect to essay number 393 of 2016 was concluded yesterday, but they want to make further submission so that the substantial question of law is correctly decided by this court. Both the councils have no objection with respect to further submissions in connection with essay number 393 of 2016. Consequently, further submissions have been heard and is recorded as well. What the
I'm there.
learned counsel for the appellant has submitted that the property of Rudru Gop was self-acquired and his next generation would not constitute a co-partner amongst themselves, and therefore upon death of two full brother of
Kedari.
Gidhari Gop, the property would devolve upon Gidhari Gop, and therefore Gidhari Gop would be allocated share of 3/4 of the property. He submits that each of the brothers who were sons of Rudru Gop would constitute separate co-partnery with respect to the property as and when the third generation is born.
Yes.
There is no question of devolution of property of one brother in the second generation. नहीं, बस इतना
No,
इतना ही
boss,
बहुत है।
it might. Now, your lordship had yesterday given an example that if father is there, he has two sons. Two sons are there. Then one of his sons has only one son, and the other has 5 sons. So what would happen?
Yes.
So then, in that case, your lordship, the first generation, that means his own son, what was the number of his own son? The property would devolve on them
Half an hour.
first half an hour, and then whatever his half share would again, he would constitute a co-partnery along with the his own son and grandson with regard to only half of the share. That would not
So
go to
the
the
branch
other
of one son would be half,
Yes.
and the branch of another son would be
half.
irrespective of number of branches.
Yes. Now, therefore, now the concept. Therefore, I said that today morning I got all this. Now, why this fluctuating interest is there in co-partnery is that your lordship, if I am being a son of inheriting the property from my father, it is my ancestral property in my hand. So whenever my son, grandson is there, then because I am inheriting the ancestral property, therefore I, along with my son, grandson, would have joint interest on the entire property which I have inherited, and I do not have exclusive right vis-a-vis my son and grandson.
But your right with respect to the property vis-a-vis your brothers is
Brother
not
would be
affected.
would be absolutely clear. There's no, it would not go to the brother and
Yes.
no.
First thing, Your Worship, I would like to show.
No, first you tell us. I just want to know whatever he has submitted is incorrect or correct.
Part to which partly correct, but
Which
not
part
fully.
is correct and which part is incorrect?
Brothers, so far as the brothers part is concerned, I will show from the Hindu law itself that what is important in law, whether there is a proportionality, whether the
No, I just want to see. I want to know which portion of his submission is not correct.
He is saying that first of all he is saying there was no co-passionary. He is
No
assuming there is a
co-passionary
co-passionary.
amongst the four brothers.
Among four brothers. And
This is his case.
That what he is saying.
Yes.
What he is saying that once the Gudulu group died, the property devolved upon him. Thereafter only there is a question of any co-passionary or not. That should be the millennial generations. That's what he is
Each
submitting.
brother would constitute separate co-passionary qua their
First
descendants.
of all, his first submission is that there is no co-passionary with respect to the Gudulu group. And what would I understand from his submission?
Udrugop and his four sons.
Portions. So so at that point of time there is no question of a passionary, it is a question of succession.
That's
So as per him, as per him, the succession, out of succession, everybody will get 1/4. And if suppose the 2% dies, the entire share of those two brothers, and because he were the full brother, it will devolve upon him, not to the half.
That's
This is what is his solution.
That's
My lord submission is that my lord, in the judgment of the recent judgment of Honorable Apex Court, also in the case of Vinita Sharma and Marcus
नहीं, आप उनको दिखा दीजिए।
आपका दिखाएं।
जो भी आप रेफर कर रहे हैं आप
हम दिखाएं।
साइमल्टेनियसली
अब उस जजमेंट में भी आज के समय में भी लिविंग का पार्टनर्स का ही पार्टीशन हुआ। इवन सुप्रीम कोर्ट ने कहा है कि अगर कोई जजमेंट में भी अगर डिसीजन में भी जजमेंट नहीं हुआ तो वो सब केसेस में इवन स्पेशल स्टेज में भी उस पर आपको इंसर्ट करना है, आपको शेयर देना है। लेकिन दैट मींस विद रिस्पेक्ट टू लिविंग कोर्ट्स। यहाँ पर अगर इस चीज को अगर डिसाइड करना हो तो ये चीज को देखना है कि हु आर द लिविंग कोर्ट्स राइट नाउ, हु आर द अर्लियर को-पार्टनर्स और नॉट को-पार्टनर्स एक्सेट्रा, वो फैक्ट उतना इंपॉर्टेंट नहीं है। लेकिन हम उस पॉइंट पे नहीं है। हमारा इसमें हजूर कहना ये है कि दो कॉन्फिडेंट कोर्ट ने कहा है कि चीजों को पार्शल और अपीलेट कोर्ट का भी जो फाइंडिंग है वो भी यही है विथ रिस्पेक्ट टू शेड्यूल बी। लेट अस सी व्हाट इज शेड्यूल बी। इसका
It is co-passionary in the hands of the third generation of Gudrugo. Whether it means co-passionary in the second generation of Gudrugo is a different point.
What is asking regarding the notional partition. Whenever a partition is made, partition is made. Lord, what would be the share as per the law? That is what is the notional partition. Who was alive at that time? Who was dead at that time? But you Laship make only question. Who are the parties before the court for partition?
That we are noted.
Yes.
That it is the
So-
third
so-
generation, fourth generation, they are the parties.
And for even for his arguments, but if it is not conceived that my lord, so far as the Gardari is concerned and my lord the Bola is concerned, as per him also that the descendants will constitute a corpus as per him.
Each one of them.
Each one of them.
They say that each
So
rank will constitute a corpus.
far as the two brothers to that, for which the substantial questions of law are different. Whose share will go to whom? This what is the question before this court. My lord, may kindly appreciate. My lord, first of all, if it is assumed that my lord, it would my lord, it will be by the succession. Then my lord, during the lifetime of Godoli Gop, none of the sons will have any share.
That's
It is also correct. And my lord, during the lifetime as per him, it is his pleading. It is his pleading that he got Jathans and etc. That has been disbelieved.
That has been disbelieved.
Disbelieved. So whether it is a question of fact, whether there was any succession after the death of the Godulu Gopals, this is the first question. So suppose for a moment, if those two sons died prior to the death of the Guru, there is no question of their shares.
That's it.
There is no question.
That is not the case.
Or if suppose for
That is not the case here.
that I'm coming to. There is a case, there are evidence to that effect. I am showing those evidence that they did not die simultaneously. They did not die
When did they
simultaneously.
die? You were the plaintiff.
I am the plaintiff. I have evidence to from the evidence.
Whose onus was there to disclose?
I will
Who died when?
it has
You
come.
are
in the-
absolutely silent on that.
Well,
There is neither any evidence nor any
the
pleading. Who died when?
Evidence. I will show from you. That is the reason I wanted to show. From the evidence, my lord will find that two of the brothers did not die simultaneously on the same date.
Certainly, nobody will assume, and nobody is going to presume
So
this.
if for a moment, if suppose one brother died, what will happen? And that in the lifetime of the father, then it will,
One-third share.
there is no question. There is
There's no question of further
no
division.
question, no.
Only one third.
Let me-
One third each.
One third each.
That's it.
One third each. And suppose then the very is pleading that 1/4 each, that's why through that will not happen.
So therefore, you are the plaintiff. You tell us that you are entitled to half because these two persons had died prior to death of.
But
Where is it?
I agree to that position, that I had to state everything. But my lord is also well aware. In a partition suit, everybody is a plaintiff, everybody is a defendant.
Yes.
It's well settled principle of
You see, we are faced with a record that does not disclose the date of death,
But-
nor does it disclose as to when, who died when.
Yes, that is what I am submitting.
Yes.
When the records does not disclose. And my lord, he wants preference. My lord may kindly see evidence act. He should bring the evidence, not I.
So you are shifting onus to each other.
Yes,
Very good.
this is what is the 101 say. The person who did not produce the evidence, and if suppose in absence of that evidence, if the court cannot declare, then my lord,
When you claimed half, right? When you claimed half,
yes.
was that onus not on you to say that
Yes,
these two
I have-
persons
I have-
had predeceased Gudrugo, and therefore by way of succession,
But-
the property would devolve half and half
I
both
have
of them?
discharged my honest point. I have discharged, but I am saying so because your lordship will find that there are, my lord, records of rights on record, in which there is recording half and half, and to that they had challenged it entry, and that till this honourable court, my lord, that has been affirmed. It has not been set aside. And my lord, in this section 84 of the my lord, Chotanagpur Tenancy Act, when a records of right is prepared, it has a presumption of correctness. It is a rebuttable presumption. I agree. But my lord, and when a person who himself,
What is that exhibit? Exhibit number?
yes, I will show the exhibit. It is exhibit 1 to see. I may be permitted to record
1 to?
record some color.
Can you put it? 1 to C.
Yes.
Exhibit 1 and 2C.
हाँ तो चार पांच खतियान
इस प्रॉपर्टी का एक ही खतियान होगा ना?
नहीं इसमें इस प्रॉपर्टी पर दो खतियान है और बाकी दो ठो इंडिपेंडेंट नहीं है।
सॉरी?
वो जो कि शेड्यूल सी वाला प्रॉपर्टी इंडिपेंडेंट
वो शेड्यूल सी में कहाँ जा रहे
हम
हैं?
नहीं जा रहे, हम दिखा रहे हैं।
इस प्रॉपर्टी का शेड्यूल बी के प्रॉपर्टी का
हम
खतियान।
शेड्यूल बी का प्रॉपर्टी में ही दिखा रहे हैं। इसको हम जो तक ये सारा होल्डिंग पेज है, इसमें ज़्यादा नहीं।
Schedule B is relating to, this is with relating to
ये
schedule B.
खाता नंबर 26 का देखा जाएगा तो ये
25 है ये, 26 नहीं.
उधारी को
This is 25. 25.
ये गिरधारी को इसके बाद वाला देखा गया इसके बाद वाला देखा गया गिरधारी को गुरु को एक अंश सच अंश बोला गया एक अंश
इनको बोलिए मार्क.
दोनों का समान
मार्क करने. लीजिए इनको. ये आपका केस है ना,
हाँ,
which is your specific case as a plaintiff.
हम हाँ
That Gondu Gop and Mithu Gop, they died issueless and their branches were extinguished
Yes.
and their share devolved upon Girdhari Gop.
नहीं,
आपका केस है ना?
गिरधारी गोप एंड भोला गोप,
आपका जो केस है उसी का बात कर रहे
उसी का
हैं. Their share devolved upon Girdhari Gop. You came
एंड उसमें आगे पढ़ा जाएगा.
who became shareholder to the extent of 8 आना.
8 आना एंड ईच दोनों है, उसको पूरा से पढ़ा है. पीस मील में पढ़ने से तो
पीस मिल में नहीं पढ़े, अब तो जजमेंट से पढ़ रहे.
पूरा पढ़ना. ये नोट को हमने मार्क किया है.
हम जजमेंट से ही पढ़ रहे. देखिए अगर आपने हाफ क्लेम किया है ना, उससे
हाँ.
ज्यादा आपको मिलने का तो कोई स्कोप नहीं है.
तो हम हर
आपने हाफ क्लेम किया और हाफ आपने इसलिए क्लेम किया बाय सेइंग दैट अपॉन डेथ ऑफ these two persons it devolved upon me.
हाँ,
यही आपका केस है.
और
That you said that by virtue of succession you received their share. It itself goes to show that they were alive at the time of death of Guru Gop.
तो कह रहे हैं कि अगर ये दोनों प्रॉपर्टी जो है, ये प्रॉपर्टी जो बुजुर्ग का प्रॉपर्टी है, वो दोनों भाई के नाम से अगर इसका ज्ञान बना, वो भी हाफ एंड हाफ, दैट इज इट हैज अ प्रिजम्पशन ऑफ करेक्टनेस.
Presumption ही है ना.
नहीं, ये चैलेंज किए, दैट हैज बीन
ठीक है, चैलेंज किए. Presumption है, अपहेल्ड हो गया. Presumption of correctness with regard to possession.
पोजीशन हाफ एंड हाफ का पोजीशन. अच्छा, हमारा ये भी पोजीशन है, और हाफ का पोजीशन है, और ये चीज आया है रिकॉर्ड में. तो हमारा जो प्लीडिंग्स है वो तो इससे अफर्म हो रहा है, डॉक्यूमेंट्री एविडेंस भी
इसमें
है.
दिया हुआ है गिरधारी को,
हाँ,
पिता गुड्डू को,
हाँ,
व विष्णु क्या को,
हाँ,
पिता भोला को,
हाँ,
जाति सचिन सर.
हाँ,
ठीक है.
समान अंश, आधा समान अंश लिखा हुआ है.
कहाँ से हम पढ़े समान अंश?
हम पढ़ रहे हैं,
पढ़िए, इधर पढ़ रहे हैं.
26 पढ़ रहे हैं.
चल अभी आप 28 निकाल के दिए हैं
26
और पढ़ रहे हैं 26.
26 भी 28 दोनों पढ़ रहे हैं. 28 देखा.
28 समान अंश कहाँ लिखा है? कहाँ लिखा है समान अंश?
26 भी देखा.
28 भी तो बताइए ना.
अच्छा,
28
26
मार्क करके दिए.
28
28 में तो नहीं है समान अंश.
समान अंश नहीं लिखे हैं, लेकिन दोनों का लिखे हैं.
ठीक है, दोनों का लिखे हैं,
गिरधारी
लेकिन समान
गोप
अंश तो नहीं
पिता
लिखे हैं.
पिता सत्यन सर, ग्वाला सत्यन सर, ये
समान अंश तो कहीं नहीं
22 में
लिखे.
नहीं लिखे हैं, लेकिन 26 में आपको. दोनों का एक एक अंश. गिरधारी गोप पिता गोटू गोप एक अंश, राम गोप सज्जन सर वही कॉन्नोटेशन है, एक अंश. एक अंश समान.
26 मिलेगा तो ना, तो 26 मार्क ही नहीं करते.
जी नहीं, मार्क
26 में मार्क किए हैं.
किया, उसी पे मार्क दो ही तो मार्क.
28 दिख रहा है,
नहीं,
ये 27 दिख रहा है. तो हिंदी में 27 ही पढ़ेंगे ना 26 को. हिंदी में तो
27
एक जगह ये हमको मार्किंग दिख रहा है.
एक 26 देखा. दोबारा से निकालो.
और किसी पेज में कहाँ कोई मार्किंग है? और किसी पेज में मार्किंग है?
हम देखेंगे.
आप एक ही जगह मार्किंग किए.
ये दो जगह तो.
अच्छा, इधर है.
हमें ख्याल है.
हाँ. 26
गिरधारी गोप, गुरु गोप एक अंश, राम गोप और विनु गोप.
एक सेकंड धीरे धीरे पढ़िए.
फिर देखो.
फर्स्ट कॉलम गिरधारी को.
गिरधारी गोप पिता गुरु गोप
हाँ.
एक अंश. ठीक है.
एक अंश.
हाँ, ठीक है.
हाँ.
राम गोप वो विनु गोप लाटो गोप पिता भोला गोप. जो
राम गोप
plaintiffs-
कौन है? राम गोप कौन है?
सब प्लेंटिव्स हैं. भोला गोप के लड़के.
राम गोप इज थर्ड जनरेशन.
सेकंड ही. भोला गोप के लड़का है तो सेकंड ही.
सेकेंड जनरेशन गुगरू के बाद तो 4 भाई हुए, उसके बाद ये थर्ड जनरेशन,
ठीक।
ठीक है। राम गोप इज थर्ड जनरेशन। आगे पढ़िए।
राम को वो विनु को
हाँ,
लाटो को पिता भोला को एक अंश समान, इन लोग सबका आपस में समान। तो लेकिन दोनों अगर इसको अगर इंटरप्रेट करें तो दोनों पार्टी का हाफ हाफ है। इनका जितने भाइयों के साथ इनका एक अंश है, उसका एक अंश है।
गिरधारी गोप के नेक्स्ट जनरेशन का तो कोई बात ही नहीं लिखा है
जी
इसमें।
जी।
गिरधारी गोप का तो लिखा है, लेकिन बाकी जो उन लोगों का
नहीं,
लिखा है वो नेक्स्ट जनरेशन।
गिरधारी गोप और भोला का, इसको दो चीज को ऐसे समझा जाएगा। तो गिरधारी गोप का एक शेयर में एक अंश लिख रहे हैं ये, और बाकी जो इन लोग जो टोटल लोग हैं उनका एक अंश लिख रहे हैं। इसको इंटरप्रेट करेंगे तो हाफ एंड हाफ होगा। वहाँ पर भी आपको दूसरा वाला में जो हमने दिखाया वहाँ भी वही बात है। गिरधारी गोप की तरफ सच एंड सच, वो विनु गोप।
ये जो शेड्यूल बी प्रॉपर्टी है,
ये शेड्यूल बी,
एक सेकंड, 28 और 26 दोनों है ना?
हाँ
ठीक है, 28 और 26 दोनों है, एक में है दूसरे में नहीं है, तो अपने आप में कॉन्ट्रीब्यूट।
छब्बीस 28 दोनों शेड्यूल बी
कैसे आप दोनों को रिकंसाइल करेंगे?
जी,
कैसे रिकंसाइल करेंगे?
दोनों एक ही है, दोनों का हाफ हाफ है।
कैसे? 28 में तो नहीं लिखा।
हाँ, उसको पूरा से पढ़ना है।
कैसे हम लोग इसका 26 का कैसे 28 में पढ़ लेंगे?
नहीं, जो उसका कन्नोटेशन उसको अगर
कॉनोटेशन ही पढ़े।
आप पूरा उसको पूरा से उसको और एज ए रीड एज ए होल पढ़ते हैं।
एज अ होल मतलब हर एक खतियान तो अलग अलग पढ़ेंगे ना?
हर एक खतियान है, लेकिन उसका जो पल्स है वो वही
ऐसा
है।
यहाँ पे इंटरप्रेट
अगर ये अलग है जैसे, तो अलग वाला हम पढ़ रहे हैं। इनका गिरधारी गोप वाला अलग है, भोला गोप वाला अलग है। उसमें
तो ये जो प्रॉपर्टी है, एक में जाएगा सर्वाइवरशिप से और एक में जाएगा
ये तो हम कह रहे हैं कि ऐसा नहीं होगा।
ऐसा नहीं
और
होगा ना।
उसके लिहाज से शेड्यूल सी पर भी रिपोर्ट का फाइंडिंग सही है, क्योंकि एक बार अगर आप
शेड्यूल सी में क्यों शिफ्ट कर रहे हैं? प्लीज डोंट शिफ्ट, प्लीज डोंट,
ठीक,
दोनों को नहीं मिक्स
नहीं,
करिए। यू जस्ट कांट मिक्स दिस।
अभी नहीं करेंगे। आई विल आर्ग्यू दैट इसको लेंगे। शेड्यूल बी पे जब खतियान भी अगर हमारा प्लीडिंग को सपोर्ट कर रहा है, और इनका सारा डिनाइल के बाद जब कोर्ट का फाइंडिंग दो कंट्रोल कोर्ट का फाइंडिंग आ रहा, तो इसको कोर्ट ने भी कहा है कि इसमें कोई बंटवारा नहीं हुआ, इसका बंटवारा करिए, आधा का बंटवारा करिए। Some more
लिखिए जाए, the counsel for the respondents has submitted that so far as schedule B property is concerned, it consists of khata number 26 and 28, and the khatiyan in khata number 26 reveals that it was shown in the name of Girdhari Gop on one part and in the name of Ram Gop, son of Vinu Gop, who was and grandson of Bhola Gop, one part. However, so far as khata number 28 is concerned, from the records, from the khatiyan, there is no separate bifurcation with respect to the shares. The learned counsel submits that the record of rights was challenged by the appellant, but they did not succeed, and accordingly the half and half share of Girdhari Gop on one hand and branch of Bhola Gop on another has been rightly.
There is one more document on record, that is Exhibit 4, that has also been looked into by reports, both reports. वो एक तरह का चार्ट है, अवार्ड है, उसमें भी इन्हें भी आधा मिला है ना ध्यान। एक्विजिशन उसका कोई शायद फर्स्ट अपील भी पेंडिंग है।
उसका पेंडेंसी का क्या ही करें?
नहीं, ये तो पंचायत में तो आधा है, वो Exhibit 4 देखा।
That has not attained finality even as per you.
नहीं, so far as
How do we look at that?
उसका अगर कोई अपील पेंडिंग है, तो वो तो एनहेंसमेंट के लिए पेंडिंग है।
नहीं, कैसे पता?
ठीक है,
एक से शेयर के लिए पेंडिंग हो
उसको
सकता
हम नहीं भी माने। तो ये पंचायत के ऑन रिकॉर्ड है, जिसमें दोनों को आधा आधा
It
मिला।
has
ये
not,
हमने denied।
not yet attained finality.
Maybe.
Maybe means what?
Maybe means-
Any proceeding which has not yet attained finality, how do we take judicial notice of that? And even if it is exhibited, suppose there is a judgment of first appeal pending here, right? And trial court judgment is exhibited. First appeal is pending, second appeal is pending, or even the matter is pending before Supreme Court. We can't take care of that. Unless it is certainly unless it is.
If the law you the pendency will be may consider, may not consider, but so far as unless there will not be something has not been set aside, it has a sanctity in the law. It has a validity in it. Apart from
The
that,
learned counsel has also submitted that. Award कौन से property का बना?
part of it.
Which property? खाता number 26 और खाता number 28.
सुलानामा के आधार
सुलानामा के आधार पर बन गया था, तो और भी
ऑब्जेक्शन
प्रॉब्लमेटिक। एग्जिबिट 4 बताइए।
जिला हजारीबाग से पंचायत 19 और 48 पंचायतें उपस्थित है, इनमें अर्जित भूमि के भुगतान के लिए अनुरोध किया।
When was this prepared?
जी,
When was this prepared?
एग्जिबिट
It is exhibit number 4.
पंचायत 4 के सेकंड पेज पे देखें, page 2 of the that agreement। बहुत से लोगों का अवार्ड है, उसमें से 4 नंबर रसवा देवी का, उसमें लिखे इस पंचायत 4 के विरुद्ध रामा गो वगैरह हम लोग आवेदन प्रस्तुत किया गया, जिसमें आधी राशि का भुगतान का अनुरोध किया गया। दोनों के बीच में दिनांक 7/1/89 को एक सुलहनामा आवेदन वायलेटेड माय फाइन 20 से पढ़।
Yes.
दोनों के बीच में सुलहनामा आवेदन समर्पित किए, जिसमें सूरज नायक वार्ड कमिश्नर सज्जन सच के आधार पर दोनों पक्षों को भुगतान का अनुशंसा की, जो अभिलेख में सदा। तदनुसार सुलहनामा एंड सज्जन सच के आधार पर पंचायतों को भुगतान दिया है।
ये किस प्रॉपर्टी से रिलेटेड?
सुलहनामा में
And where is that? Where is that Sulanama?
no, I'm sorry, that is not all.
Then this document is reflecting nothing.
But he had not disputed it।
Disputed means
ये इसका जब ये कोर्ट ने इसे दोनों कोर्ट ने कंसीडर किया है,
कंसिडर किया। जब आप रेफर कर रहे हैं तो हम देखेंगे ना डॉक्यूमेंट, कि ना देखें हम इसको, बिकॉज यू आर नॉट एबल टू फाइंड आउट एनीथिंग अबाउट योर पेपर।
जरूर हालांकि इसमें ऊपर में आया
The learned counsel
Yes,
for
yes, page three.
the respondent.
पेज
Yes. बताइए।
नहीं
The learned counsel for the respondent has also referred to Exhibit 4 to submit that the award was also prepared upon acquisition of land in case number 16 of 8788 as back as in the year 1989 on the basis of compromise, and it was prepared half and half. However, upon perusal of the said document, he has not been able to point out as to which plot number it was relating. Particularly, there is no mention of any khata number on the same. The joint compromise has also not been brought into. However, the learned counsel has submitted that the dispute in connection with allocation of compensation, in connection with the compensation, is pending before this court. Correct?
Whether it is.
Perhaps, Matlab?
I have not checked. Fairly
Then why did you say?
as per the order of the
Which case number दिया हुआ है? Is pending before this court as per the order passed by the learned appellate court, first appellate court. और बताइए क्या है? So you are harping upon the record of rights.
I am happy upon the records. And I would like to show some evidence.
What evidence do you? Whose evidence? With respect to, on what point do you want to show the evidence?
With respect to death.
Death. According to you, according to the evidence, right? Who died when? पहले आप हमको बताइए, फिर हम evidence देंगे. भोलू को Is there any indication who died when? Who predeceased whom? कम से कम इतना एविडेंस होना चाहिए.
ये 12(5) में एक 2 पॉइंट पर डेथ को डिपेंड है. ये PW 1 का में डेथ पॉइंट.
किसका एविडेंस पढ़ना चाहते हैं? PW 1 का. और किसका पढ़ना चाहते हैं? बताइए किसका? पहले विटनेस बताइए.
लेकिन वो उसके
PW 1 इसमें पढ़ेंगे ना? बताइए PW 1 का क्या है? क्या चीज़ पढ़नी है?
ये वादी नंबर 2 है.
ठीक है.
वादीगण एक साथ मिलकर बंटवारा बांध रहे हैं. मैं सभी की ओर से साफ दे रहा हूँ. इस बात से संबंधित तकरारी जमीन को जानता हूँ जो पूर्ण रूप से अर्जी B एवं C का दर्शाया गया है. दोनों पक्ष के पूर्वज गुरु गौ थे जो अपने जीवन काल के सर्वे से पहले ही जमीन मौजा जमीरा सज्जन सर के अंदर अर्जित किए थे. वक्त के रजिस्टर्ड सर्वे के अंदर खाता नंबर 7 में दर्ज हुआ और गुरु गौ गारंशियल मालिक के परिवार के कानूनी के जिम्मेदार. खाता नंबर 7 जो है गुरु कैडेस्ट्रल सर्वे का है, वही 25 जो अभी दिखा रहे थे वही वाला जीवन. ये गुरु गौ को 3 लड़का गिरधारी को हिंदू गौ मिठू गौ पहले पत्नी से. ये भी ये क्लेरिफाई कर रहे हैं कि दे वेर फ्रॉम द फादर.
इसमें तो कोई डिस्प्यूट ही नहीं.
कोई नहीं क्लियर आई है. और जिसके अंदर 2 लड़का हिंदू गौ और मिठू गौ नाबोध पुत्र. गुरु गौ पहली पत्नी से मृत्यु के बाद दूसरी शादी की, जिसे एक लड़का भोला.
So after the death
कर रहे हैं तो इसे भी शी इज अ लीगली वैलिड वाइफ. ये वफात गुरु गौ के दोनों लड़के गिरधारी गौ और भोला गौ के संयुक्त दखल हुए और लड़के बलम होने के नाते संयुक्त परिवार के मालिक और कर्ता बने. ये दोनों गौ
नहीं ठीक से पढ़िए. ये वाला पैरासिक्स ठीक से पढ़िए. ये की बात
ये बात वफात गुरु गौ के मरने के बाद उनके दोनों लड़के गिरधारी गौ और भोला गौ अपने बारे में कह रहे हैं और इनके बारे में कह रहे हैं. पर संयुक्त दखल का और गिरधारी गोप के बड़े होने के नाते संयुक्त परिवार के मालिक लोग करता है, जो कि हम सेकंड केस में भी इस पर रिलाई करेंगे, तो एपेलेट कोर्ट ने भी रिलाई किया। दोनों भाई गिरधारी गोप एवं भोला गोप बाह्यसियत संयुक्त परिवार के सदस्य एवं संयुक्त आमदनी एवं खाता संख्या 7 से प्राप्त करते हैं। ये भी हम सेकंड केस के लिए हम इसको रिलाई करेंगे। इस आमदनी से दोनों भाइयों के भूतपूर्व जमींदारी से बजरिए रईती बंदोबस्ती के मौजा बुजुर्ग जमीरा में हंसी, इसमें स्पेसिफिक इन्होंने कहा है कि हम लोग उसी के आमदनी से ही किए, और दोनों भाई उपरोक्त जमीन पर दखलदार बिना बंटवारा। गिरधारी गोप अपने पीछे 4 लड़के एवं दो लड़की छोड़ के मरे, जिसका बड़ा लड़का बोधन गोप नावल मर गए और बाकी 3 लड़की और लड़की के परिवार के लोग बाद में अधिक सलामत को मौका।
से क्या डिराइव करते हैं? इससे क्या डिराइव करना चाहिए?
ये पुराना खाता 7 के जो नया खाता 26 एवं 28 तैयार हुआ, और दोनों खाता संयुक्त रूप से गिरधारी लोग एक हिस्सा एवं भोला को 3 लड़कों रामा सत्यन सच के नाम से एक हिस्सा बराबर, कारण भोला एवं वासुदेव को पहले मारा।
देखिए, जो फाइंडिंग ऑफ फैक्ट इस प्रॉपर्टी से रिलेटेड आपका दोनों कोर्ट में रिकॉर्ड हुआ है।
क्या चीज़?
दोनों कोर्ट में फाइंडिंग ऑफ फैक्ट विद रिगार्ड टू दिस प्रॉपर्टी जो रिकॉर्ड हुआ है,
हाँ हुआ।
उसके बियॉन्ड तो नहीं जा सकते
नहीं
ना
जा सकते।
तो फिर हम लोग क्यों ही देख रहे हैं?
और भी है जो सब्सटेंशियल क्वेश्चन ऑफ लॉ, उसके रेस्पेक्ट में सिर्फ 2 ही चीज़ देखना। पहला तो कि ये
सेक्शन 18 फॉलो किया कि नहीं?
फॉलो किया गया कि नहीं, या हो सकता है फॉलो हो सकता है कि नहीं। और अगर एपेलेट कोर्ट को या ट्रायल कोर्ट को इसके आधार पर इनका प्रॉपर्टी इन्हें अलॉट करना चाहिए था, हमें सिर्फ 1 कोर्ट। यही क्वेश्चन ऑफ
नहीं, आप किस क्वेश्चन ऑफ लॉ के लिए आप इस तरह से हमको
हम
एविडेंस
इस-
नहीं
हम
पढ़ा
इस तरह
सकते।
से-
आप हमको बताइए ये क्या, आप इससे क्या प्रूव करना चाह रहे हैं?
हम इससे
What is it that you want to prove, and what is, which fact has been recorded wrongly in the trial court judgment, and what relevance would it have so far as the question of law is concerned?
yes, क्वेश्चन ऑफ लॉ के लिए हम ये दिखाना चाहते हैं कि इनका जो है, जो सेकंड वाइफ जो है वो उनसे ये लड़के हैं, जो उसके
इसमें तो no dispute,
हाँ, नहीं हमने कहा था इसलिए हम दिखा।
दिखाने की जरूरत नहीं है। There is a finding of fact to that effect. There is no dispute on this. अगर आप हमको ये दिखा सकते हैं कि these 2 persons, 2 sons of Gudru Gop, predeceased Gudru Gop from the record, तब तो हाफ एंड हाफ में तो वो तो है ही नहीं है। यहाँ पर
ये चीज तो नहीं है।
कैसे प्रिज्यूम करेंगे बाप की
इसका-
बेटा बाप के सामने
इसका
बन गया?
डेथ- इसका डेथ
Your Lordship reverse है. Your Lordship may see para statement in para 3 and 4. Only 3 lines of both paragraphs I may be allowed to read. First, they say in para 3 that Gudru Gop had 2 wives from the first wife I had read this earlier. He had 3 sons, Gidhari Gop, Gundu Gop, Mitu Gop, but later on 2 sons died issueless and their branches were extinguished and their share devolved upon Gidhari Gop, who thus became 2 so and so. And Gundu Gop had another son, Gola Gop, who became co-sharer of it. Now, para 4. Absolutely clear. Thus, after the death of Gudru Gop, his said sons jointly inherited the lands of Khata number 7, which became their ancestral joint family property in the hands of Girdhari Gop and his brothers. Girdhari
ये
goat
सब
and his
इंटरनेट सब
brother.
लोग नहीं देख सकते. This is not possible.
And Bhola goat each having children. So therefore, at the time of when Budru goat died, his
ठीक.
all 4 sons were alive.
इसमें और कुछ बोलना है आपको?
हाँ.
बोलिए. Mr. Sharma, we can't keep waiting for you to open the page. आप जल्दी करिए. आप ऐसा पेज पलटते हैं तो आपको मार्क आपका जूनियर लोग हेल्प नहीं करता है फ्लैग करने में, मार्क करने में.
Three 61 second edition.
क्या चीज़? कौन सा सेकेंड एडिशन?
20th edition.
पेज नंबर
Page number
361
360.
ऑफ मुल्ला. कौन सा एडिशन?
First.
कौन सा एडिशन?
20th.
28 एडिशन. फर्स्ट वॉल्यूम. हिंदू लॉ ऑन मुल्ला 20 28th एडिशन फर्स्ट वॉल्यूम पेज नंबर 360. बताइए क्या बोलना चाहते हैं.
इसमें बताना चाह रहे हैं कि conception of joint Hindu constituting proportionally in that of common male ancestor with his lineal descendants in the male line within 4 degrees counting from and inclusive of such ancestors of 3 degrees inclusive. No proportionally can commence below the common ancestor through and after the may consist of collaterals such as brothers, uncles, nephews and cousins. ये my friend was
Your Lordship had pointed out.
नहीं हो सकता.
I've also made a note.
वो चीज पर भी दिखा देगा. ऐसा भी नहीं हो सकता है, ऐसा भी हो सकता है.
The learned counsel, by referring to the aforesaid page, has referred to Article 212 dealing with formation of propastory and has submitted that the conception of joint Hindu family constituting a propastory is that of a common male ancestor with his lineal descendants in the male line within 4 degrees counting from and inclusive of such ancestor, within bracket, or 3 degree exclusive of the ancestor, bracket close. No copastry can commence without a common male ancestor, though after his death it may consist of collaterals such as brothers, uncles, nephews, cousins, etc. The learned council, by referring to this, has submitted that all the 4 brothers of Rudrugo, all the 4 sons of Rudrugo, they constituted co-partners.
मतलब ये जजमेंट बार बार इसको लागू करते थे, इसमें शॉर्ट करने का इतिहास
Also said,
ये विनीता शर्मा वाला जजमेंट है, इसमें 66, 69, 73 and 1.
the learned council has also referred to the judgment passed by the Honorable Supreme Court reported in bracket 2020, that close 9 SCC 1, Vinita Sharma versus Rakesh Sharma, and has referred to paragraph number
Team 66, 69, 73 and 1.
66 क्या paragraph से शुरू हो रहा है, इसीलिए पूछ रही हूँ, पढ़िए 66 में कौन सा paragraph?
Section 6(1) पर deemed partition. Effect of no disruption of proportionally by a statutory function of partition till actual partition takes place. हालांकि this is with respect to women rights, but proportionally as a concept has been dealt in national partition etc. बहुत सी चीजें इस जजमेंट में लिविंग कंपाशनर्स का भी लास्ट पैराग्राफ में important काम है।
ये आप इसमें मार्क करके बताइए क्योंकि वो टैली नहीं करते, तो ये इनको दीजिए।
इसका पैराग्राफ
सो बताइए कौन सा है, वो तो साइमल्टेनियसली हमको दीजिए, वो देख के बताएंगे। उसमें पैराग्राफ मार्क किया हुआ है एआईआर में, एआईआर का पैराग्राफ बताइए कौन कौन सा?
पैराग्राफ 66
66
66, 69, 73 and 1.
73 and
1,
130
20,
1
20.
129 बस 66 69 73 and 129 इसको मार्क करिए आप। Yes, mark it. To submit that the co-partnership continues till there is actual partition. यही आपको, and therefore the learned court has rightly held that the property was co-partnership.
Now, my lord, I won't argue this matter. Second, the friend has already argued.
Arguments in connection with
ये एक लाइन है
ऐसे
वो चूंकि because he has pointed out a thing which would be
अच्छा in response बताइए।
which Hindu law in which he placed now. Your Lordship may allow me to read it, which I have read. the conception of a joint Hindu family constituting a co-personary is that of a common male ancestor. That is A. Let us assume there is A. Of a common male ancestor with his lineal descendants. So here if we apply Bondhu Gop along with his lineal descendants, if they constitute a co-personary, then what would happen? In the male line within 4 degrees, counting from and inclusive such ancestor, that means Bondhu Gop, or within 3 degrees exclusively in so and so, no co-personary can commence without a common male ancestor, that is A or Bondhu, whatever we say. Though after his death, that means after Bondhu Gop's death, it means that co-personary of Bondhu Gop and his descendants, it may consist of collaterals such as brothers, uncles. That means amongst themselves they may be nephews, uncles, among the descendants, not relating to the
In
Amata.
response, the learned counsel for the appellant has submitted that in order to form co-personary qua the property, there has to be a co-personary and also co-personary property. The learned counsel submits that the brothers / sons of Bondhu Gop did not acquire the property as co-personary property.
Yes.
And therefore each branch of 4 sons along with their descendants, they form co-personary.
Separate co-personary.
Separate co-personary. यही है?
Yes.
भाई दोनों चाहिए ना, co-personary family भी चाहिए and co-personary property भी चाहिए.
हाँ, एकदम.
अगर
So-
दोनों नहीं होगा तो property co-personary की
And
तरह
let us
divide
assume
नहीं हो
that
सकता.
there is a property which is undivided. So
तो वो
whatever
तो होगा ही.
interest he had,
That will go
only
accordingly.
that would go to his branch and his descendants, and they would have
अब ये जो है ना
fluctuating.
363 में कंक्लूड कर दीजिए आप. दूसरा बताइए.
First point, my lord, I have already yesterday I had said, illegality in reversing a finding is not a substantial issue. My lord is well aware. My lord, even an error, my lord, in a judgment, or my lord, is in a error in a fact, if unless it is perversity, not my lord, if there is a perversity, my lord, it cannot be a substantial issue. My first submission would be that the very framing of this substantial question, not that the illegality in reversing the finding, that itself is not a substantial question. There are judgments, I will rely on those judgments, that illegality in a judgment is not a substantial question.
With respect to this appeal, कौन सा दूसरा नंबर है? SA number 402 of 2016, the learned counsel for the respondents has submitted that illegality in the findings recorded by the learned courts by itself is not a substantial question of law, but only in case of perversity, the same can be a substantial question.
That is my first question. So far,
And you rely upon the judgment. It relies upon following judgment. लिख के दीजिए मिस्टर. होमवर्क नहीं करते हैं. AIR का साइटेशन सीनियर को थमाते हैं और यहाँ पे जो है SCC का साइटेशन दे देते हैं. AIR का साइटेशन देना चाहिए ना जो आपके सीनियर के पास है. हाँ? कोर्ट का ही बुक था तो बुक लिस्ट देने का किसका काम? यस. कोर्ट का बुक हम लोग मंगा लिए तो बहुत गलती हो गया हमसे. Committed a mistake.
we will learn.
He is not learning adequately. जितना आप सिखा नहीं रहे उसको ठीक से.
Yes, just join.
Just join क्या?
ये 2 महीना में
अरे क्या बात आप?
So that if Manoj will take that into consideration, we'll do it fast.
My entry in my first senior's office before I got enrolled was only because of the fact that I had read reference Delhi Rent Law Act in full text. I was interviewed on that. तो ये बच्चा लोग का कहानी हमको मत सुनाइए, ठीक है? Mr. P.K. Sinha, you know how hard he was.
हम इन लोगों को कहते हैं कि आपको कोर्ट में जाके बैठना चाहिए और माइलॉर्ड से का कमिटमेंट सीखना चाहिए। हम अक्सर इस बात को कहते हैं। Malord, the second thing that I would like to point out, that Malord, it is now Malord, as per both the judgments, though my friend has filed a second appeal, Malord, and that is under challenge. But Malord, both the courts have put that Malord, so far as the Schedule B property, it is a property.
Schedule C.
Schedule B.
अब Schedule B में मत आइए, अब Schedule C.
Schedule B तो पर ही हम रिलाई करके Schedule C चलेंगे।
अच्छा। Both the property, both the courts have found that Schedule B property
It is a co-partition.
was co-partition.
And it was never partitioned by mutual.
There is no dispute on this.
Yes.
That
Now-
there has been no previous partition. There is no dispute on this that there is a joint family.
Yes.
इसमें कोई dispute
दोष
नहीं।
पिट नहीं। अब हमको ये हमारा ये करना है कि when अगर ज्वाइंट फैमिली है, ज्वाइंट फैमिली का प्रॉपर्टी है, सबसे पहले हम ये दिखाना चाहते हैं अपने प्लीडिंग से, जो कि अपलेट कोर्ट ने भी कंसिडर किया है कि ये एक ज्वाइंट फैमिली प्रॉपर्टी था और इसको फैमिली इनकम से, जो कि खाता नंबर 7 का, जो कि शेड्यूल बी का इनकम, उस प्रॉपर्टी से इन्होंने इसे परचेज किया है और इट वाज एक्वायर किया है बाय सेटलमेंट। दोनों आदमी ने सेटलमेंट से एक्वायर किया है और उसमें इनको आमदनी, जो कुछ भी आमदनी थी, बिकॉज वो ये एक डॉक्यूमेंट के अलावा या ये इसके अलावा कुछ और रिकॉर्ड में नहीं है कि देयर वाज अदर इनकम्स टू बी। तो शेड्यूल बी का जो एरिया है 30 डिसमिल से भी 30 एकड़ से भी ज्यादा, 30 एकड़ से ज्यादा, जो कि लर्नेड ट्रायल कोर्ट ने भी कंसीडर किया था। लर्नेड ट्रायल कोर्ट ने भी कंसीडर किया था कि हाँ वो है, और हमने अपना एविडेंस भी पढ़ा था पीडब्ल्यू में, दोबारा पढ़ना चाहते हैं। पारा 7 में हुजूर PW1 का जो पारा 7 उन्होंने कहा, पारा 7 का हुजूर देखा है, पहले हमें हमारा प्लीडिंग, पारा 6 मेरा प्लीडिंग देखा है। अपील कोर्ट नहीं हम पढ़ते हैं, पारा 6 में अपील कोर्ट ने लिखा फ्रॉम द गोइंग,
एक सेकंड तो वहीं से
अपील कोर्ट से अपील कोर्ट में पारा पेज 21 इंटरनल पेज 21
पेज 21
पेज इंटरनल पारा 25 क्रॉस Learned counsel for the appellant submitted that finding of issue number 7 and such are not correct, and further emphasized that exhibit C is an evidence of separate acquisition of property as well as the law. From going through the contents of the plaint, White Para 6, it is pleaded that the land belonging to Khata number 25, 27, 103 and 140. These are all part of the Schedule C. We are jointly acquired by the Godhari Group and Ola Group, and the Godhari Group bought recorded bigger area in the name by Khata number 25 and 27, and lesser area in the name of Ola Group under Khata number 113 and 14. Though they were joint owners, each having equal share. In the written statement by Para 21-22 of the written statement, the fact has been denied, and the lands of these 4 khatas are proportionary property. Has been denied that these lands of these khatas are proportionary property, and that has been acquired out of joint family fund. There is no pleading in the written statement that the khata 25 and 27 were acquired by the Dhari group out of his personal income, and a vague reply will be mentioned. My first submission, Your Lordship, is that so far as the pleading part has been considered, that has been taken note by the applicant. Now, my Lord, I would like to read para 26. The court, while para 48 of his judgment, had discussed the issue and concluded there is no evidence on that what income the expenditure and what was the saving of the joint family because of this after expenses of the amount which is called nucleus and the joint family. PW1 while para 41 has stated that khata number 25, 27, 1218 with the Majarua land as has been certified in the name of Bihari Group and Bola with respect to khata number 25, 26 and 27, 24 respectively. In the evidence, we have supported our the pleadings that has been taken into consideration by both the courts. PW1 evidence has been considered.
What is the date of acquisition of this property?
After the cadastral survey.
When was cadastral survey done?
Cadastral survey in the khata number 7 itself. It was something around 1900. But it is not in dispute that khata number 7 was in the from that itself the regional survey. After the regional survey, these two schedule B's khata has come out. This is
Date
not
of acquisition of this property has not been mentioned.
इसमें ये चीज आया है कि तो अपना इनकम से इसका
Date of acquisition of this property or year of acquisition of this property is not there.
सेटलमेंट से
कब?
सेटलमेंट का तो डेट
नहीं है ना?
लेकिन ना इनका है ना मेरा
ठीक है, किसी
दोनों का नहीं। और ये भी कोई अपना सेटलमेंट का डेट नहीं बताए हैं या इनका भी कोई और कोई दूसरा इनका बिल्डिंग भी नहीं है कि हाँ इसमें हमको इस दूसरा कोई आमदनी से हमको हुआ है या कुछ और है, इसको भी तो कोर्ट ने कहा है। हम आगे बढ़ते हैं। DW4 by para 11 of this gross examination has Vodulu Group has the land in the khata 26. What is Vodulu Group का भी गवाह करा। From the above statement, I find that the land pertaining to khata 25, 27, 28 were not of self-acquired property of the Bihari Group and Bola Group, rather it was jointly acquired by persons constituting a joint. There is no separate income of the parties. The DW4 has stated in his cross-examination by para 33 that Bola Group नहीं पॉइंट आउट कर पा रहे थे, इसमें देखा जाए DW4 खुद का stated in his cross-examination by para 33 that Bola Group deceased Girdhari Group and later we are looking after all the business of it. हमारा बोला पहले डेथ हुआ और यही देख रहे हैं। Which further corroborates the pleading and statement of the pleading. DW4 being the oldest witness and he has occasion to see Buduru Gop and has appended to Shraddh ceremony of Bodhu Gop and Vidu Gop appears to be the most trusted witness on the facts pleaded by the party. Therefore, I find that the finding of the lower court as far as issue number 4 and 9 are concerned are satisfied and it is ordered that Schedule C does not fall under the category of proportionality. However, it was a joint family property and the liable to be partitioned among the parties between the Girdhari Group and Bola Group and Half. But so far as the question of law, which my learned friend has yesterday denied, that there is no presumption that the joint family possesses a joint property also. And a person who says that it is a joint family property, the onus your lordship is first on him. He should first discharge it, then it will shift to the defendant. But from my pleadings and my evidence also, in the evidence of PW1, there was no cross examination on that aspect. That I will also show from the PW1 witness. So, my lord, it is an admitted, my lord, when an examination in chief, my lord, and a statement is made, and my lord, if there is no cross-examination on that aspect, then the evidence, my lord, stand admitted. So, my lord, the party had made acquisition, my lord, out of the income of, my lord, Khata number 7, my lord, which is a very large area, which is scheduled B, admittedly as per the, my lord, the judgment passed by trial court as well as the appellate court. That is now a proportional property that has already been declared. So, my lord, so far as, my lord, the nucleus is concerned, we have made a pleading, and, my lord, to that effect, my lord, evidence has also been reduced. To that effect, evidence. Now the question, my lord, that it is, my lord, the law your lordship. Several judgments have been, my lord, examined in this my lord, case itself by the Honorable Affairs Court, which my friend is relying on. I will also rely on that. 2003, volume 10, SCC 310. Yesterday, my lord,
10 SCC.
2003, volume 10, SCC, page 300.
300.
10.
310.
310. Yesterday, my friend has given a copy.
Yes, Lakshmi.
And this judgment, my lord has also relied several times. In one of my cases, also your lordship has relied. My lord, in this particular case, the Honorable Judge, Honorable Apex Court, your lordship, has relied upon several judgments and has discussed several judgments and has come to a finding and has held that there should be some nucleus that your lordship may kindly see. There is no presumption of property being joint family property only on account of the existence of the joint family. The one who asserts has to prove that property is a joint family property. If, however, the person so asserting proves that there was a nucleus with the joint family property could be acquired. What is could be acquired? There would be presumption of property being joint family, and then onus would shift on the person who claims it to be self-acquired. But not so far as the plaintiffs are concerned. They have discharged their own. And my lord, nothing has been done by the defendant. That has been taken into consideration by the appellate court. I was reading it. If there is no evidence on it. And how they acquired the property, by virtue of what money they acquired property, or how they acquired property, nothing from them. So far as we are concerned, my lord, the plaintiffs have not only pleaded, but your lordship has adduced evidence, and my lord, so far as the my lord, Schedule B property is concerned, my lord, admittedly it was in the name of both the parties, half and half, my lord, that I have already shown, my lord, from the Atyan itself. My lord. So, 7th, my lord, Khata number old CS Khata number 7, my lord, admittedly was a joint Khata, and both the parties were, my lord, cultivating, my lord, as per their convenience. There was no partition by means. And there is nothing on record, my lord, that has been taken into consideration by the appellate court, that there is any other source of income by either of the parties. So the primary source of income in Lordship was, my lord, the agricultural income, and that too, my lord, from old Khata 7, that we have already pleaded. So far as the nucleus your lordship is concerned, may not have, my lord, details regarding what was the saving and what is etc. This that, but it was a large family. Both of us were a large family. Several members of the joint families were residing, and the area was more than 30 acres. Then, my lord, it can be, my lord, it can show some light that, my lord, the property which was required, there was every likelihood of acquisition of those property by the income of that. So that aspect of the matter, I would say that so far as we are concerned, we have already discharged, my lord, the evidence and our onus, and my lord, thereafter the onus was shifted on them. So no, he has not been able to discharge. And so far as the reasoning, your lordship is concerned. So far as the reasoning, your lordship is concerned. The reasoning has been assigned. Reasoning has been assigned by the learned appellate. Learned trial court, despite taking into consideration of these aspects, only under erroneous consideration that there must be some very specific things, that what income, how much of income, the learned trial court would not take into consideration that the law is that it would have been required. And so far as the nucleus aspect is concerned, the evidence was considered by the learned trial court, PW1, and other evidences also. And he was also, he has also even recorded, but I will show it from the learned trial court judgment. The evidence has come that it was a 30 acres of land. That part I will am reading.
That has come read yes.
Yes. So far as the income.
30 acres of land, which land?
Schedule B.
Does it say that it was 30 acres of Schedule B land?
Yes.
Which paragraph? Can you read it?
Sir, it's खाता number 7.
खाता number 7.
वो खाता जो कि original हो गया है.
ठीक है. खाता number 7 is 30 acres. कहाँ?
Yeah. Yesterday my friend had read up.
There is evidence that the family possesses 30 acres of land. शेड्यूल बी तो 30 एकर्स है ही नहीं, तो कहाँ से एविडेंस आ जाएगा? भाई शेड्यूल बी का एरिया तो शेड्यूल बी में लिखा है ना, तो उसके बियॉन्ड 30 एकर्स कहाँ से हो जाएगा? देखिए जरा शेड्यूल बी कितना है?
एरिया में हो सकता है बहुत सा सोलर भी तो हुआ है
भाई, जो आपका एरिया लिखा हुआ है उसके बियॉन्ड तो नहीं देखेंगे ना हम लोग?
अब ठीक हमने पढ़ा, देखिए
उससे पढ़ने से
से
आप हमको बताइए, शेड्यूल बी आप बोल रहे 30 एकर्स, इट इज नॉट दैट। शेड्यूल बी का प्रॉपर्टी डिटेल्स लिखा हुआ है,
मान
अब उसके बियॉन्ड हम क्या
हमने
देखें?
ठीक है शेड्यूल बी का हम मान लें, लेकिन अगर टोटल अगर फैमिली का अगर पोजीशन का ही बात करें तो ठीक है ऐसा बात, और हम ये कह रहे हैं कि एग्रीकल्चरल इनकम के सिवा कोई इनकम नहीं था, और ये कोर्ट भी ट्रायल कोर्ट भी कह रहे हैं, ये सिर्फ इस बात पर इसको डिक्लाइन कर रहे हैं कि ये स्पेसिफिक नहीं बताया कि कितना इनकम था, कहाँ था, कितना बचा था, लेकिन न्यूक्लियस तो था, इनकम तो था, और हमारा तो क्रेडिट भी है कि हाँ हम लोग दोनों ने इसे एक्वायर किया है, और ये एक डॉक्यूमेंट्री एविडेंस है ताकि दोनों का एक्विजिशन हुआ है।
The learned counsel for the respondents has also referred to the judgment passed by the Honorable Supreme Court reported in bracket 2003 bracket post 10 SCC 310, which has also been relied upon by the counsel for the appellant, and has submitted that though there is no presumption that the property is a joint family property merely because there is an existence of joint family, but once the nucleus is proved, then under such circumstances, once the nucleus is proved from which the joint family property could be acquired, the onus shifted upon the appellants to plead and prove the source of income from which they acquired the Schedule C property.
Yes.
Yes. The learned counsel submits that there is finding of the learned court that there was nucleus in the family. The quantum of nucleus is not relevant. Right?
Yes. One more thing. One more thing.
Yes.
Admittedly, this is a question of fact.
This you have already said.
Question of fact. And my lord is well aware. The learned appellate court can reverse the finding and can give his non-finding. there is no bar. And so far as the discussion aspect and the reasoning assigned is concerned, my lord, the paragraphs of the plaint has been referred. My lord, the paragraphs of the written statement has been referred. And my lord, what is the evidence available on record? These are PW1 evidence. These are the only evidence which is available on record. Even Exhibit E is one evidence which has also been considered, which shows the some portion were sold out, etc. Those evidence are also on record.
Sold out by who?
Some
Who sold it?
party subs.
Parties means?
हमें हमारा ही
यही बेचे
हमरा मिला
आप बेचे हैं ना?
अल्लाह
आप बेचे हैं ना?
अल्लाह हम कब खुद
तो जब आप बेचे हैं तो उसमें तो इनको पार्टी नहीं बनाए बेचने के समय।
ये तो हम वही वो चीज कोर्ट कहा है कि अब जो उनका वाला जो अपना वाला था इसलिए
अपना वाला कैसे बेच दीजिएगा? अगर
नहीं।
जॉइंट फैमिली प्रॉपर्टी है तो एवरीबॉडी हैज टू जॉइन इन।
पार्टीशन बाय बिट्स एंड पाउंड ऐसा है वो रखा है
उसमें कहाँ लिखा है कि जॉइंट फैमिली प्रॉपर्टी है इसलिए अनडिवाइडेड शेयर बेच रहे हैं?
ऐसा नहीं
नहीं है ना?
एग्जीक्यूटिव
बेचते समय आप एक्सक्लूसिव ओनर बन जाओ
नहीं
और उसके बाद पार्टीशन के समय उसको पार्टी विल बिहेव लाइक दिस ओनली।
उसमें तो
सिलेक्टिव
मौखिक बंटवारा करके लिखवा देते हैं लोग दे देते हैं माई लेकिन हमारा कहना ये है कि इट इज ए क्वेश्चन ऑफ फैक्ट। अब क्वेश्चन ऑफ फैक्ट पे अगर कोई फाइंडिंग है अपीलेट कोर्ट का, उसका भी रीजन भी है, सब कुछ है, तो उसका रिवर्सल अगर अपीलेट कोर्ट ने किया है, वो सब चीज कंसीडर करने के बाद उन्होंने कह दिया कि नहीं होगा। एक तो ये एक लास्ट एस्पेक्ट हम कह रहे हैं कि जब ये प्रोपोर्शनली
एक सेकंड, the learned counsel for the respondents has also submitted that the learned appellate court has considered not only the pleadings of the parties but also the evidence on record and has passed a reasoned judgment. There is no occasion for this court to enter into a finding of fact. It is not necessary for the learned appellate court to deal with the findings recorded by the learned trial court by
findings he has discussed.
that the learned trial court has wrongly decided.
No, right. After discussion, making everything, conclusion part was as because it was wrongly decided, so that part has only been reversed.
चलिए लास्ट सेंटेंस
एक लास्ट हम मुझे बस खाली एक ही सबमिशन
बस लास्ट सबमिशन, उसके बाद
उसके
फिर एक
बाद
और
हम-
मत ऐड
एक
करिएगा।
मिनट है।
ठीक, बताइए
एक
क्या
लास्ट ये
सबमिशन?
करना चाह रहा हूं कि
बताइए।
प्रोपोर्शनरी प्रॉपर्टी अगर है तो उस कंडीशन में अगर सेपरेट पर्सन्स ने भी, अगर जॉइंट फैमिली मेंबर्स ने भी अगर सेपरेट एक्विजिशन भी किया है, तो वैसे कंडीशंस में प्रोपोर्शनरी अगर है तो उसे जॉइंट फैमिली माना जाता है। उस पर एक जजमेंट भी हम देंगे। नाइनटीन 1994 आंध्र प्रदेश 154।
बताइए क्या बोलना चाहते हैं? क्या बोलना चाह रहे हैं?
Separate property of a member of a joint family may be impressed with character of a joint family property to currently owned in the common stock with the intention of abandoning his separate family. Separate property of the Hindu ceases to be a separate property and acquires characteristics of joint family or ancestral property, not by physical mixing with the joint family or ancestral property. but by volition in intention, by leaving the surrendering the separate rights, the separate. हम ये कहना चाहते हैं, मीन्स जब एक बार कोर्ट ने दोनों कोर्ट ने कहा दिया कि देयर वाज ए जॉइंट फैमिली प्रॉपर्टी विद रिस्पेक्ट टू शेड्यूल बी, तो अंडर देन मतलब द प्रिजम्पशन विल अराइज कि सेपरेट होते हुए भी ये चूंकि उसी प्रॉपर्टी से ये परचेज हो रहा है, तो इट इज ऑल्सो ए जॉइंट, जो कि एपेलेट कोर्ट ने कहा। बस यही एक जजमेंट है जो हम तैयार करेंगे। इसमें पुराना भी जजमेंट का सुप्रीम कोर्ट का कुछ रेफरेंस है, हाई कोर्ट का जजमेंट है, लेकिन
The learned council has also relied upon the judgment passed by Honorable Andhra Pradesh High Court. Reported in report बताइए।
AIR 94 1994 AIR आंध्र प्रदेश
1994 AIR Andhra Pradesh 134. To submit that, in the earlier judgment it has been held by Honorable Supreme Court that the separate property of a member of joint Hindu family may be impressed with the character of joint family property if it is voluntarily thrown by him into the common stock with the intention of abandoning his separate claim therein. और आपको मिला कौन कौन सी जजमेंट का पैराग्राफ बताइए, कौन सा एससीसी वाला पैराग्राफ बताइए, पैरा नंबर बताइए ना, मार्क मतलब नंबर बताइए, ऑर्डर में लिखाना है। पैरा नंबर पैरा 60 और 73 129 और
तो वही सब बात सिर्फ पढ़ा था उसका।
पैराग्राफ 66 पैराग्राफ 60 तो इसमें है ही नहीं।
66
पैराग्राफ 66 69 73 एंड 120
सेम पढ़ा है, वही सब पढ़ा
इसमें 128 लिखे हैं।
है। उसमें 129
There is difference in paragraphs. I have marked the literature.
पैरा 128 लिखे हैं, तो 129 कैसे बोल रहे हैं?
In AIR and my book,
AIR का पैराग्राफ तो हमने ऑलरेडी लिख चुके हैं।
that's one. I marked it.
ये जो विनीता शर्मा वाला जजमेंट है ना 2020 वॉल्यूम 9 एससीसी, उसमें पैराग्राफ 66 69 73 एंड 128। आपको कुछ बोलना है?
Bas, 2 minutes. Your Lordship, the entire finding of the trial court was with regard to Schedule C that the plaintiffs had not been able to prove that there was sufficient nucleus from which these properties could have been acquired. Now the plaintiff in his claim very clearly himself admits that they were acquired by the two persons, that is Girdhari Go and Gola Go, in their own names. This is their statement in the claim. But it was acquired by way of the joint fund, joint family property. This was his case. So he was required to prove what was the nucleus and whether it was sufficient nucleus or not. The entire argument that sufficient nucleus is not required to be proved is absolutely erroneous in view of the same judgment which I have just relied upon. This is 2003 volume 10 SCC. Your Lordship may see from para 10, the Supreme Court has relied on 3 other judgments. I will only place relevant portion. Para 10, Your Lordship may see, in Srinivas Krishna Rao Kango versus so and so, then the last 5 lines of the same paragraph. The important thing to consider is the income which the nucleus yields. A building in the occupation of members of the family and yielding no income could not be a nucleus out of which acquisitions could be made, even though it may be of considerable value. So let us assume that it was 30 acre, it was 200 acre. Then also, if it does not yield any income, then it has absolutely no value. Then it says, on the other hand, a running business in which the capital invested is comparatively small might conceivably produce substantial income which may well form the foundation of subsequent acquisitions. Then para 11. In Moody Gowda versus so and so, then after 3-4 lines, it is only after the possession of an adequate nucleus is shown that the owner shifts on to the person who claims the property as a self-acquisition to affirmatively make out that the property was acquired without any aid from the family estate. Then Your Lordship may come to para 30. In Surendra Kumar versus Purchand, this court held that where it is established or admitted that the family which possessed joint family, which from its nature and relative value may have formed sufficient nucleus from which the value in question may have been acquired, the presumption arises that it was joint family property and the burden shifts on so and so, the party alleging to sufficiently affirmatively that it was acquired without its.
The learned counsel for the appellant in response has submitted that it was a specific case in the plate that two brothers bought properties in their own name, but at the same time it was pleaded that the property was purchased from joint family fund, was acquired from joint family fund. The learned counsel submits that not only the existence of nucleus but also the sufficiency of required nucleus is required to be proved, as the income generated from the joint family property or joint family fund should be enough to sustain the acquisition of the property which is claimed to be joint family property in spite of standing in the name of individual persons. He has again referred to the judgment passed by the Honorable Supreme Court reported in bracket 2003 bracket close 10 SCC 310 and has referred to the earlier judgments referred to by Honorable Supreme Court at paragraph 10, 11 and 13 to submit that mere existence of nucleus is not sufficient. Adequacy of nucleus is also required to be proved. That's
Last
all.
line.
The judgment is not.
Para 5 of their plate may kindly be taken note.
हाँ.
Para 5. That after last cadastral survey, both Girdhari Group and Bhola Group jointly out of joint family fund, that is, they themselves say, that is incomes from the lands of old Khata number 7, acquired some more land by settlement from the then landlord in their own names, which having acquired out of the land from co-customary property became the joint. So they themselves say that income was there.
He has
So
in
they were
particular
required
referred
to
to paragraph 4 of the plate.
para 5.
Para 5 of the plate. Sufficient हो गया?
फ्रेंड जो अभी जजमेंट रेफर कर रहे हैं उसका कंक्लूडिंग पार्ट तो पढ़ेंगे
अरे कुछ तो हम भी करेंगे कि नहीं करेंगे?
नहीं पारा 18 पढ़ लिया जाए
आपको लग रहा है कि पैरा 18 हम नहीं पढ़ेंगे?
इतना जजमेंट के
क्या आपको लग रहा है कि हम पैरा 18 नहीं पढ़ेंगे? चलिए अब इसको कंक्लूड करें। कल का सबमिशंस, आज का सबमिशन सब कंसोलिडेट करके हम लोग को डालना है। कल का तो कल में डलाएगा क्योंकि आज इन्होंने पूरा रीहियरिंग किया है, एक पर्टिकुलर पूरा नहीं, थोड़ा फर्दर हियरिंग किया है, तो इसको करके ही इस ऑर्डर को अपलोड करेंगे। These dictations whatever I have given in the court will be uploaded as it is with the dictation. ऐसे CA भी नहीं, whatever you have submitted will be recorded and uploaded. And then it's 1-2 दिन लगेगा करेक्शन करने में।
ठीक।
वो आपने नहीं दिया, आपने जो भी मुल्ला का रेफर किया है पैराग्राफ दे दीजिए
वो
भाई।
सब दे दें, सब दे दें।
हाँ एकदम प्लीज बी केयरफुल अबाउट व्हाइल गिविंग इट। और अगर अच्छा होगा कि मतलब यहीं पर ही फोटोकॉपी हो जाएगा या मान लीजिए वो मोबाइल से क्लिक कर लेंगे वो पेज।
ठीक है, then I'll make a Xerox copy and
हाँ
then I'll
प्लीज दे
submit.
दीजिए, नहीं तो बहुत दिक्कत हो
नहीं,
जाएगी।
वही कर रहे हैं।
आप ही कर लीजिए उसको शाम मतलब सेकंड हाफ तक कर दीजिए इसको। वॉल्यूम भी लिखेंगे कौन से वॉल्यूम से लिए हैं, है ना, पार्ट 1 वॉल्यूम भी और एडिशन भी, कौन सा एडिशन।
Addition, but you will achieve that golden book which all three, both of us relying on
ठीक है,
that.
खाली एक बार बोल देंगे।
हाँ ठीक है, 20th edition.
हाँ, गोल्डन बुक, यस
हाँ.
इट इज गोल्डन। चलिए आप continue।
From daily list for orders to defect item 2, CMP filing number 7712 of 2024.
What is this CAP for? This was dismissed for non-person. Defective है क्या? CMP number 7712 of 24. फाइलिंग नंबर होगा, फाइलिंग नंबर CMP 7712 of 24, petitioner absent, time till 29th August is granted to the petitioner to remove the surviving defects peremptory if the defects are removed within the granted time post on 12th of September. Respondent present. Give you a memo. Please.
Item 3, content civil filing number 13848 of 2024.
Yes.
One
Sorry.
time.
आपको 29th अगस्त तक का टाइम देते हैं, ठीक है? Petitioner present. Parties are present. अपना appearance देंगे. Same order. Yes. What's your name? Excuse me. क्या नाम?
कुमार सिंह।
हाँ?
प्रमोद कुमार सिंह।
प्रमोद जी। ठीक है प्रमोद जी, सेम ऑर्डर।
जी
खाली यही है कि petitioner is also present.
जी।
For orders, item 4, second appeal 264 of 2016.
प्रेमट्री ऑर्डर है, आप अपना कंप्लाई करते हैं। डिफेक्ट रिमूवल का प्रेमट्री ऑर्डर है। Appellant absent. Nobody appears for the parties. Right. Post on 25th August.
Item 5, first appeal 367 of 2018 along with item 62403.
Where are the parties? बुलाइए भाई उनको। Where is Mr. मिथुन कुमार? आप कौन हैं? तो आप अपना पोजीशन, ये अच्छा आप तो अपीलांट हैं इसमें। क्या बोलना है आपको? हाँ?
सर्विस रिपोर्ट is still awaited.
FA number 203 of 2014. As per the office note, service report in connection with the following respondents is awaited. Office is directed to send an express reminder for sending the service report. Post this case on next Friday. आज कितना तारीख है? हाँ? आज 20 तारीख है। 4th of July. यहाँ पे you will find it the number of persons जिसका सर्विस रिपोर्ट नहीं आया, इसका सॉफ्ट कॉपी लेकर टाइप नहीं करिएगा, एरर हो जाता है. सॉफ्ट कॉपी लेकर you just drop it. इसको आज साइन करा लेंगे. This will not take much time. They have to send a reminder. एक चीज और, ये क्या ऑर्डिनरी प्रोसेस से नोटिस बस ऑर्डिनरी प्रोसेस करना है. Let a copy of this order be communicated to the concerned to fax.
Item 404, second appeal 396 of 2018.
The applicant filed an IU for substitution of respondent number 3.
Who has filed?
The applicants have filed an IU for substitution of respondent number 3, who had died on 6/2024. In the same period, they have paid for condemnation of delay and setting aside everything.
Okay. Applicant absent. You have heard all the respondents.
No, we have paid for respondent number 1.
Counsel for the respondent number 1 is present. IA number, he submits that interrogatory application being IA number 5826 of 25 has been filed for substitution of respondent number
Respondent number 3.
respondent number 3 along with a prayer for condonation of delay and setting aside abatement. The legal years and successors of respondent number 3 has been mentioned in paragraph number 3. Let notice be issued to the proposed legal years and successors of respondent number 3, whose details have been mentioned in paragraph 3 of the interrogatory application, for which requisites under ordinary process be filed within a period of 2 weeks from today. Let the soft copy of this order be forwarded to the learned counsel for the applicant to ensure compliance. Post this case on 8th of August awaiting service.
Item 405, second appeal 267 of 2023.
What is it?
Last provision, notices were issued, we received instruction or I have received respondent number 1, 2, 3, 5 and 11.
1, 2,
3 and 11.
3, 11. Respondent number 8 and 9 have expired.
8 and 9.
8 and 16
8 and 16.
have expired. You have not seen the office note.
I've seen this.
What is the report with regard to other respondents?
Other respondent 2, 3 son has received, and so far as 5, 6 is concerned, brother has received. 7 nephew has received. 10, 11 wife has received.
Is it a
13
partition
husband.
suit? Is it a partition suit?
So may I?
Is there any conflict of interest? Is there any conflict of interest with respect to the applicant?
Yes.
Then you have to take fresh steps for service of notice.
No, they have already. This report will be considered as valid so far as two are concerned, because all are sons.
and they are representing them. There is no conflict of interest so far in their cases.
Essay number 267 of 2023. The learned counsel for the appellant has submitted that so far as as per the service report
And so far as
of the respondent number 1, 4, 9, 12 and 14 semicolon 2, 3 semicolon 5 and 6 semicolon 7 semicolon 10 and 11 semicolon 13 semicolon and 15. The notice has been received either by themselves or by their close relatives. He submits that the notice be accepted as validly served. Any objection?
No.
The learned counsel for the appearing respondent has no serious objection to the prayer for acceptance of notice. Accordingly, the notice upon the aforesaid respondents is accepted as validly served. Mr. So-and-so has submitted that he has received instructions to appear on behalf of respondent number 1, 2, 3 and 11 and undertakes to file Vakalatnama within a period of 1 week. As per the office note, respondent number 8 and 16 have expired. Learned counsel for the appellant seeks adjournment. Pose this case on कब रखी बताइए
2 weeks के बाद हम substitution फाइल करेंगे.
25th of July.
In the meantime, soft copy of the petitions.
Which petition?
Entire set of petitions. Soft copy.
तो आपको मिला नहीं?
Soft
आपका क्लाइंट आपको नहीं दिया?
only IE petitions.
आप इनसे मांग लीजिए. We'll give you. You provide him a hard copy. Provide कर दीजिए. Soft copy, hard copy जो चाहिए. When other side is appearing with the records, unnecessary others you can.
Item 406 CFP 150 of 2024.
Yes.
Let us invite minutes to the last ordinance, 25th of April. This CMP is preferred for restoration of another CMP which could dismiss for non-prosecution. So there is a private opposite party and he was noticed. Now the status of that service of notice was to be brought forth by filing an affidavit.
So, ladyship, we have filed a counter related to this ladyship. We have served the notice ladyship to the son of the respondent number 6 ladyship because the respondent number 6 has died ladyship.
You'll have to file substitution. CMP number 150 of 2024. The respondent number 6 has been reported dead. Counsel for the petitioner seeks adjournment. Post on 25th July.
Item 407, first appeal 221 of 2024.
This case, notices to all the respondents have been validly served and some of them have also appeared, except respondent number 7. So the notice was returned unserved to insufficient lordship's address. Lordship, we have filed one IR for certificate service of notice on respondent number 7. Lordship, we are aware only of that address which is mentioned in the title suit. So we are not saying that if publication may be allowed in the district of Dhanbad, where is address was.
IA number 6997 of 25. In first appeal number 2221 of 2020. The learned counsel for the appellant has submitted that in spite of best of effort, notice upon respondent number 7 could not be served and therefore a petition has been filed for substituted service of notice. Who is respondent number 7?
She is one of the defendants.
The learned counsel submits that the last known address of respondent number 7 is on Dhanbad and therefore appropriate order with regard to service of notice, substituted service of notice upon respondent number 7 be passed. Counsel for the respondents has no objection to the payment. Why have you filed a power of attorney?
Because Lordship, the applicant number 1, who is the main contesting plaintiff, is aged about 76 years. Lordship is not in a position to travel. So he has given power of attorney to his
All
son.
right. That's considering the aforesaid submissions, let the notice be served upon the respondent number 7 through substituted service of notice by way of paper publication in 2 newspapers, one Prabhat Khabar and another in Telegraph, having circulation in Dhanbad. The format of notice be filed by the appellant before the registry within a period of 2 weeks from today.
Instead of
The
telegram,
registry is directed to verify the format and give it to the and hand it over to the counsel for the appellant, so that the same be published in the aforesaid newspapers, and the affidavit within a period of 1 week thereafter. The affidavit annexing the newspapers be filed before this court within a period of 4 weeks thereafter.
so I was only requesting
Pose this case on 29th August or maybe later, 12th.
instead of telegram, Lordship may kindly allow us to publish in Times of India or Hindustan Times. We don't know if telegraph is widely circulated in Hindustan.
Times of India. Telegraph की वजह Times of India. Both having circulation in Delhi, Dhanbad.
Item 402. Item 408, CNP 4627 of 2024.
What is this CAP for?
For the restoration limits, the restoration of the second appeal.
CAP number 627 of 2024. What is the office to put policy?
It's not there.
Sorry?
It's not there.
The counsel for the appellant has not seen the office report. Close this case on 29th August. Till next.
Item 409, CRMP 512 of 2025.
Yes.
4 लाख अरेंजमेंट
My lords, the order dated 28th of March.
पेमेंट करना था मैडम 4 लाख अरेंजमेंट आया
Para 3 of the said order would be the operative part minutes.
क्या कर रहे हैं?
पेमेंट होने पे अरेंजमेंट कर रहे हैं कि 4 ही लाख हो पाया है 15 दिन का और दे दीजिए हम कर देंगे मैडम इंटेंशन कहा जाएगा तो आज हम पार्ट जमा कर सकते हैं पार्ट में डिपॉजिट कर देते हैं
पार्ट जमा करके आते ना?
अभी
क्या बात?
जब आज अरेंज हुआ है कुछ वेट 2 लाख रुपए ट्रांसफर अकाउंट में कर रहे हैं किसी लोग उधार मांगे हैं अभी 1 घंटे में कर रहे हैं इसीलिए आज कर देंगे
तो मंडे को रख देंगे?
मंडे को हम पार्ट कर देंगे
पार्ट नहीं, मंडे को पूरा।
नहीं मैडम तो
2 लाख रुपए ट्रांसफर कर रहे हैं, 4 लाख रुपए जमा
नहीं
हो
चाह रहे हैं वो 2 लाख दे के 2 लाख रुपए है मेरे पास आ रहा है अपना एफडी है 1.5 लाख वो तोड़ेंगे 50 लेके आए हुए हैं और 2 लाख रुपए अकाउंट में ट्रांसफर करने
छोड़ेंगे
वाले
कब? 28 मार्च का ऑर्डर है। बताइए, इतना इंटेलिजेंस हम लोग नहीं दे सकते। We will discuss this case right now.
चल 15 डेज
Why 15 days?
Thereafter, the matter was posted on
इंटेंशन
the.
है मैडम हम पेमेंट करते हैं अरेंजमेंट होने पाए अरेंजमेंट हो जाए फिर कर देंगे हमारे
जेल में जाइएगा तो वहाँ से अरेंजमेंट होगा।
नहीं लगे हुए हैं उधार के लिए कुछ किसी को मारना पड़ता है
नहीं, ऐसा नहीं होता ना। NI एक्ट है। इंटरेस्ट भी दीजिए सर।
मैडम
दीजिए इंटरेस्ट।
प्रिंसिपल अमाउंट तो मुश्किल से कर पा रहे हैं, अभी तो होता तो हम कर देते, अभी भी कर
ऐसा है,
देते।
जब आपके पास पैसा नहीं है तो जेल इज द बेस्ट प्लेस। खाने को नहीं है, पैसा नहीं है, कपड़ा नहीं है, छत नहीं है,
मंडे में
रोटी, कपड़ा और मकान, ये 3 चीज जेल में उपलब्ध।
लॉर्डशिप हम फाइल करने के लिए इधर इतने रेडी हैं, हम अरेंजमेंट लगे हुए हैं, खाली 15 डेज का दे दिया हम कंप्लीट कर देंगे, या फिर हाफ का हम कर देते हैं, हाफ 15 डेज के बाद कर देंगे। इंटेंशन हमारा पेमेंट का ही है अभी।
प्रीएम्प्टिव ऑर्डर कर देते, राइट, बाय वे ऑफ लास्ट चांस कर देते हैं। ही विल फाइल एफिडेविट ऑफ डिपॉजिट
Yes.
in the account. If he does not file the affidavit, it will stand dismissed. CRMP number 512 of 2023. The learned counsel for the petitioner submits that he is still in the process of collecting arranging the amount of rupees 5,50,000.
5,25,000
Sorry?
कोर्ट बिलो में 25,000 पेमेंट ऑलरेडी किया हुआ है।
हम नहीं जानते, जो आपका इसमें ऑर्डर लिखा हुआ वो यही।
फर्स्ट डेट में ही था मैडम उसमें।
आई डू नॉट नो, जो ऑर्डर में है वही ना चलेगा।
फर्स्ट टोटल में मैडम है ऑलरेडी, कोर्ट बिलो में कंप्रोमाइज हुआ था उस दिन वो।
देखिए जो यहाँ पर रिवीजन का ऑर्डर है वो 5.5 लाख का ऑर्डर है बस, और हम नहीं जानते।
Three of the order number shows his billing days also.
अपीलेट कोर्ट का ऑर्डर में ही था।
5,50,000.
हाँ ये है, बाद में आया।
5,50,000 in terms of the order dated 28th of March 2025. He submits that by way of last indulgence, 2 weeks time may be granted. Counsel for the opposite party.
Not state.
Oh. Where is the OP number 2?
नोटिस नहीं हुआ मैडम।
Notice नहीं हुआ।
एक्सटेंशन टाइम जो
Let the order time till July is granted to the petitioner to comply the order dated 28th of March 2025, failing which this petition shall stand rejected without reference to the bench. एक सेकेंड, 4 मत करिए, 11th of July to file an affidavit regarding compliance of order dated 28th of March 2025. ठीक है, और बाकी पेमेंट if the order is complied, post this case on 18th of July.
For admission, item 410, content civil 211 of 2023.
Compliant, Your Lordship. Last occasion, only 3 months, you request Your Lordship with regard to the
Compliant?
No, Lordship. One thing is this, Your Lordship, regarding the interest on the pension, Your Lordship. Yesterday I received the counter affidavit, Your Lordship. And it seems from the counter affidavit that interest on the pension amount has not been paid.
Why have you not paid the
last
interest?
occasion only 3 months was with regard to the interest and gratuity. Your Lordship directed me to pay the interest. Your Lordship, in this regard, we have specifically filed with SOCO, Your Lordship, study itself. In which the all payment has been paid, Your Lordship. As far as the pension is concerned, the earlier occasion the SOCO was filed and it has been stated in Parai that that has been fixed, Your Lordship. And so far the interest is concerned, only stating last occasion that interest and gratuity is left.
So where is the interest?
Yes, Lordship.
Where is the interest? And which is that component? बताइए, कहाँ लिखे हैं कि interest has been paid?
Yes, Lordship. The para 6-7, Your Lordship. With regard to the
पढ़िए पैरा 6-7 में interest का कौन सा कहानी लिखा है?
file dated 17 June, Your Lordship.
कहाँ लिखे इंटरेस्ट के बारे में?
Para 8 and 9, Your Lordship, with regard to the gratuity part is concerned, that is stated and submitted that
Show
there
me
are
one word from your entire affidavit regarding payment of interest.
payment of interest. Yes, Your Lordship.
बताइए. Show it to me. डायरेक्शन था इंटरेस्ट पेमेंट का. बताइए कहाँ है? बताइए ना कहाँ.
Your Lordship,
पैरा 10 का कंप्लायंस बताइए.
para 10.
पैरा 10 ऑफ द फूड्स ऑर्डर का कंप्लायंस बताइए.
So, एक केस में बस पॉसिबल कर दीजिए इसको. तुरंत हम दिखा देते हैं कि 5-6 एफिडेविट फाइल हुआ है. लास्ट वीकेंड सिर्फ एक ही ग्रीवांस था तो उसी को बस लेकर के हम सामने आए.
कौन आपके एफिडेविट फाइल करते हैं जो आपको बिना इंस्ट्रक्शन के आप एफिडेविट फाइल करते हैं?
नहीं, इंस्ट्रक्शंस है.
कौन है? उन्हीं से बात करें. आपसे आप बात नहीं.
सिर्फ एक केस के लिए पॉसिबल कर दीजिए. बस तुरंत हम दूसरे एफिडेविट को शो कर देते हैं.
पैरा 10 ऑफ द ऑर्डर का कंप्लायंस दिखाइए. पैरा 10 ऑफ द रिटर्न. राइट?
Yes, Your Lordship.
2:15 बजे टिकट करेंगे.
Item 411, contents to 915 of 2023.
What is the status? क्या हुआ? आप ही का केस है.
Order has been complied.
कंप्लाइंट हो गया ना, इसीलिए वो धीरे धीरे चल रहा है.
Compliance has to be filed. It is ready. Those who want to file.
रेडी तो फाइल करिए. Order has been complied.
It is serving a copy.
No means what?
Kindly see this compliance order has not been compliance.
Sorry?
Not submitted here.
डिमार्केशन हुआ कि नहीं हुआ?
नहीं.
आप क्यों नहीं एफिडेविट फाइल किए? लास्ट टाइम यू वर एब्सेंट.
Kindly see the order
Last time you were
dated
absent.
21/3.
When I reached there,
कोई बात नहीं. Why have you not filed that?
Should be filed by the opposite party on 11/6/2015. Okay.
ये 2000 मतलब मार्च से ही चल रहा है कंप्लायंस रिपोर्ट फाइल करने का.
इसमें 21/3/2025 को स्पेसिफिक डायरेक्शन.
He was supposed to remain personally present,
he was
right?
present on that.
Where is he? Has he been exempted from being present before the board?
As per
Exemption order है?
the leadership on 23rd March he was present, and subsequent to which he was directed to file the compliance.
No. You see, he was directed to remain present on 23/20.25 by this order, right? He was supposed to remain present on 21st March to explain why order of this court has not been complied. Okay? On 21st March, he was present. He prays for some more time to file compliance report. Where is the compliance report?
Yes, leadership, that's what
No, where is he? Where is he? He has not. He has. There is no order exempting him from appearance, right? Nor he has filed his compliance report, in spite of the order having been passed in his presence. And last date you were absent. क्या है? कहाँ से गए हैं? रामगढ़? बोलिए आने के लिए. सेकेंड हाफ में तो हम लोग हैं यहाँ पर. आज के लिए या आपके चेंबर में बैठे हुए. Possible.
leadership, it has been affidavit today, but
We do not know. Affidavit today, it means that he has come to the
yes,
court.
leadership, yes,
Call
but we were not aware.
Call him. ठीक है. चेंबर में मत बैठा के रखा करिए कंटेनर में. फिर क्या? Affidavit today तो बुलाइए. बुला के लेके आइए. सेकेंड हाफ में.
Item 412, contents to 37 of 2024.
Order has not been complied. On 25th March 2025, your shift notices were issued to opening 2 and 3 through police station. Your shift.
They have not entered appearance. Who is opposite party number 2 and 3?
principal and secretary of the college.
Was there any direction upon them?
They have to comply the order.
They were respondent number 5 and
5 is the principal yourself, was OP number 2 herein, and direction was to
respondent number 5 was the governing body of Bokaro Mahila College through secretary.
No, it's the principal of this.
Did they? Yes.
Lord, I am appearing for the respondents.
Which respondent?
I am appearing for the respondent number 2 and 3, my lord. Bokaro Mahila College, my lord.
You have filed wakalat
I have filed a CMP for modification of the
Have you
final
filed?
order, my lord, as prayed for on the last date.
Have you filed wakalatnama?
Yes, my lord, I filed Vakalata. My name is Anjani Nandan, my lord.
It is appearing in the list. Okay. What modification
My
have you
lord,
filed?
my lord, the problem with that execution of that order was, my lord, in the writ order was, my lord, that the governing body was being directed to take a decision, my lord. But after the 1 month of the passing of the order, my lord, the governing body is not in existence till today, my lord. Therefore, on the last date, my lord, I had prayed for the modification of the order, my lord. And for that, I have already filed a CMP, my lord, 6076/2025, my lord, for modification of the writ court order.
So
Because now,
how is your
in Bokaro
institution
Mahila
running?
College,
How is your institution running? This 6076 of 23. What is the case number? CMP 6073 of 2023.
607, that is the filing number, my lord. That is the filing numbers.
Filing number is?
2000.
Give me the filing number.
6076 of 2025. CMP filing number is 6076 of 2025. Filed on 10th of June 2025.
When did your governing body become redundant? There is no governing
body has
there is no
power
stopgap.
of the governing body has been seized.
By whom?
By the order of this honorable court, it has directed the university to seize the power of that governing body.
So,
now, anyway, that governing body is not in existence, my lord, because that tenure is also over of that earlier GB. And because of the dissent of the High Court order, my lord, no new governing body has been formed.
So there must be some stopgap arrangement. There must be some stopgap arrangement made by the university.
Yes, ma'am. It is being run by only the university come representative. The UR is running along with the principal, my lord. It is just a stopgap arrangement itself.
So for compliance of the order, they can do it. What's the big deal about it? They can
The
comply
UR,
the order.
as on the last date also, my lord, I had prayed that if there is a slight modification, that a university representative, if can pass an order, my lord, then it will be, then that can be done, because only UR is only now taking care of the university.
Content Civil 337 of 2024. The Learned Counsel for the respondent number 2 and 3 has joined the proceedings online. Opposite party number 2 and 3 has joined the proceedings online and has submitted that the governing body of the college is defunct and non-functional by virtue of the orders passed by this court in another petition. He submits that stopgap arrangement has been made for functioning of the college, and in place of governing body, one representative of the university and the principal are taking care of the affairs of the institution. He has also submitted that a petition seeking modification of Order number 6/7/2023 passed in WPS number 1280 of 2017 has been filed through filing number 6076 of 2025, and the same is pending. The office is directed to post the ये जो filing number है ना, the case which has been filed through filing number 6076 of 2025 before this court on Monday. उसको Monday को कर दीजिए along with this contempt.
Right.
Monday नहीं, Tuesday को in the supplementary class list. हाँ, coming Tuesday. उस दिन आपका जो भी है डिफेक्ट रिमूव करिए, we will see what is to be done. serve copy on the other side. आपको भी copy, petitioner को copy serve करेंगे, right? You also seek instructions in the matter, right? You also.
Item 413 contains Civil 158 of 2025.
In this case, Lordship, result order has been passed but not discussed regarding the 7th pay and others. In the result order, only ACP and NACP claim of the petitioners has been rejected. Not respond any other.
7th पे का तो कोई बात ही नहीं है आपके ऑर्डर में.
इस 7th पे में क्या मिलना है नहीं मिलना है ये कम करके दे दिए.
Order was simply to decide the representation.
So you have rejected their claim for 7th pay commission.
My lords, only for the ACP and ACP that did not be given.
But the representation contained their relief in connection with 7th pay commission also. कहाँ है आपका रिप्रेजेंटेशन?
सर
7th पे कमीशन का रिप्रेजेंटेशन में कहाँ जिक्र है? छठे वेतनमान का निर्वहन. आप तो 6th पे रिवीजन में चल रहे. कहाँ है 7th पे कमीशन का कोई जिक्र है? 7वां वेतन.
Point 4 clause 4.
He has a grievance in connection with 6th पे का तो कोई grievance नहीं बचा है.
नहीं.
आप कहाँ इसको डिसाइड किए? किसने डिसाइड किया आपका रिप्रेजेंटेशन?
This is by मेरे से कुछ डायरेक्टर.
डायरेक्टर को रिप्रेजेंटेशन समझ में नहीं आता है. बताइए. Where is the consideration of 7th pay revision? That is the only thing you want? और तो कुछ नहीं बचा आपका?
इसमें कुछ पेमेंट बाकी ही रह गया था इंश्योरेंस वगैरह.
देखिए जितना वेग आपका सबमिशन रहेगा उतना ही उससे ज़्यादा वेग इनका आंसर रहेगा. आप बताइए 7th पे रिवीजन के अलावा कुछ?
रिप्रेजेंटेशन में लिखे हैं कि ग्रेचुइटी राशि भी इनको नहीं मिली है, इंश्योरेंस की राशि नहीं मिली है.
देखिए contempt civil 158 of 2025. Counsel for the petitioner has submitted that the claim for 7th pay revision has not been considered by the opposite party, number 2. देखिए आपका रिलीफ सिर्फ 7th पे तक ही था, उसके बियॉन्ड हम लोग नहीं देखे. And he has referred to the order passed by this court in WPS number 2381 of 2023, and he has submitted that there was specific prayer in connection with 7th pay commission. He has also submitted that the representation also included specific relief in connection with 7th pay commission. Counsel for the opposite party, आप कर दीजिए इनका 7th pay revision. The counsel for the opposite.
अदर ड्यूज के बारे में भी था.
अदर ड्यूज के बारे में आपका कोई रिलीफ नहीं था रिट में, ठीक है? तो अदर ड्यूज के बारे में आप दूसरा रिपीटिशन करें.
other views of it.
अदर ड्यूज के बारे में आप दूसरा उसका भी कुछ कर नहीं सकते. The learned counsel for the opposite party prays for some time to seek instruction for consideration of the claim of the petitioners with regard to 7th pay commission. आपका डेट ऑफ रिटायरमेंट कब है?
These are at least कुछ petitioner 20 में आते हैं, कुछ 21.
Date of retirement 31/1/2021.
नहीं ऐसा नहीं The learned counsel for the petitioner has referred to the representation as contained in Annexure 2 and has submitted that the claims mentioned therein has not been considered, particularly the claim regarding 7th pay commission. The claim has been enumerated in total 10 items. 10 items है ना आपका? 10 items है आपका? Yes?
Yes.
In the representation, the learned counsel for the opposite party prays for some time to find reasoned order in connection with the other items of claim in the representation, in connection with whom the reasoned order has not been passed. ठीक है? ACP, MACP दे दिया. By the reasoned order, the claim of ACP and MACP has been rejected. ठीक है? बाकी सब आइटम का भी आप दे दीजिए. Post on 29th August. The supplementary show cause be filed by 25th of August. हर एक आइटम वाइज डील करके कर दीजिए. आपको क्या? Either you allow it or you reject it.
Item 414, contempt civil 171 of 2025.
I pray for not today. The Army Council, West Bengal, has to argue this matter. Says not bail.
Who has to argue?
Neha
Sorry?
Bhardwaj. This is Jalsa matter.
Order has been complied.
No, Your Lordship, order has not been complied.
As per me, order was complied. We have also filed this report.
When did you file the show?
The last report on
13/6. लिखिए. Content Civil 171 of 2025. The learned counsel for the petitioner seeks adjournment. Counsel for the opposite party is present. A compliance report has been, a show cause has been filed on 13/6/2025. Let a reply to the show cause be filed by the petitioner by July 4th, clearly indicating the surviving grievance of the petitioner in the light of the order dated 24/2024 passed in the PPS number 7619 of 2023.
Para 7 of our super name is stated.
Let him say. अब टाइम ही मांग रहे हैं तो क्या करेंगे बताइए. पोस्ट ऑन 11th of July.
Item 415, Conference Rule 316 of 2025.
Yes, supplement. Petitioner. क्या बोलेंगे? Complied. Content Civil 316 of 2025.
One of the petitioner was died during pendency of the contempt application. Ministry has said that they have asked for the succession certificate. I simply this must submit. In the during pendency, wife has also died, and husband, the employee is also professor. So they are legal son and daughter. So they may be allowed that to produce the certificate from circle officer, genealogy of the family, and certify the college before college.
नहीं ऐसा नहीं हो सकता. वो that is a separate cause of action. We don't want to say anything more. Content Civil 316 of 2025. The learned counsel for the opposite party has submitted that the order of this court has been complied. One of the petitioners,
Petition number 4 of this contempt
petition number 4, having expired,
and the
he has
nominee
been,
wife has also expired.
They have filed this.
And his nominee wife has also
and
expired.
his nominee wife has also expired,
Therefore, we have
and therefore succession certificate would be required to remit the amount to the legal heirs and successors of petitioner number 4. Considering the aforesaid submissions, this court is not inclined to proceed any further in this contempt proceedings which is here by the petitioner.
They have sent the check to the college, not to me.
Item 416, CNP 323 of 2025.
This CNP is filed for modification of relationships order passed in CNP
Who are you?
in the petition.
Who are you?
Your Lordship.
You are not the counsel for the petitioner in the writ records. Are you a counsel? Then what modification? What modification are you seeking?
This there was a delay of 112 days in filing the SCSP. So there was a delay, continuation of delay petition which was allowed also. That is annexation number 1.
So?
But then the office report still said that the order needs to be modified.
Which order needs to be modified?
The order passed in the petition, it says that within 6 weeks it has to be filed.
You did not file within 6 weeks.
No, Your Lordship.
Why didn't you file within 6 weeks?
There was a communication here between the council and the
They
petitioners.
should have filed. What do you want? What modification do you want in WPC? You are seeking modification of WPC?
Yes, Your Lordship.
Yes. Which office notice saying? Which office notice saying? Where is that office note by which you are aggrieved? Which office note?
I mean,
The delay has already been condoned.
yes, Your Lordship.
So,
But when the matter came before the Lordship, it was suggested that the
who suggested you? Court never suggests you anything. That is not the job of the court. Court is not your advisor, nor they give you any suggestion. There is already a condonation allowed.
there was an office note, Your Lordship.
In which record there was an office note?
In the ACSB,
But that delay has been condoned. That office note does not survive anymore. Delay has been condoned. Nobody is agreed by that.
I submitted before the Lordship, but it was suggested that
Who suggested you?
I may be permitted to bring on record.
No. This is not. What kind of petition is this? You were supposed to file your petition before Jharkhand Education Tribunal.
No, that was went against us. The order was against us. Then the petition, which was withdrawn with the liberty to file appropriate appeal.
Before Jharkhand Education Tribunal.
No, Your Lordship.
Yes, of course. It will be open to the petitioner to file appropriate appeal under section 15 of the Jharkhand Education Tribunal.
As per that one, it has to be appeal has to be before ACSB.
So what is your problem? The delay has already been condoned.
Yes, Your Lordship.
Then?
But subsequent to that, when the matter was taken up, it was pointed out that since the order was that within 6 weeks, which was not complied, so that defects.
The delay has already been condoned. We don't want to pronounce anything more. Delay has already been condoned. CMP number 323 of 2025. Counsel for the petitioner submits that this petition has been filed to modify the order dated 22/3/2018, passed in WPC number 3267 of 2011, whereby while dismissing the writ petition, it was observed that it would be open to the petitioner to file an appropriate appeal under section 15 of Jharkhand Education Tribunal Act 2005 against the order impugned in the writ petition, being WPC number 3267 of 2011, within a period of 6 weeks from 22nd of March 2018. He submits that the appropriate appeal under section 15 of Jharkhand Education Tribunal Act 2005 could not be filed within 6 weeks, and there was delay in filing the appeal. However, the delay of 112 days has been condoned in ACSB number 12 of 2018, which was appeal under section 15 by the order dated 9/2/2024. He further submits that in spite of this, there is certain office note, as the appeal was not filed within 6 weeks from 22nd of March 2018. This court is of the view that once delay in filing ACSB number 12 of 2018 has been condoned, there is no need to modify the order passed by this court in WPC number 3267 of 2011, dated 22nd of March 2018. This petition is accordingly disposed of. हो जाएगा काम? I had said so that there is no need. Office कैसे defect लगाता है? When the court has condoned the delay and nobody is agreed by that.
It is pointed out, Your Lordship.
After the order of condonation of delay.
Yes, Your Lordship, and I have presented also before the Lordship that it has been ordered. Then I thought there was a difference, 113 and 112 days. Then I thought that it may be because of that one day mentioned. Then court said no, this is not the thing. Since it was after 6 weeks.
It should have been pointed out by them. But they never pointed out, delay has already been condoned. Right?
Article 417, CMP 350 of 2025.
Yes, petitioner. What is it?
CMP has been filed for restoration of rate application 4368 of 23, which was dismissed for default for non-compliance of the ladyship order, whereby your ladyship has directed to remove the defect.
Okay, CMP number 350 of 2025. Counsel for the parties are present. This petition has been filed seeking restoration of WPS number 4368 of 23, which stood dismissed on account of non-removal of defects on 21/6/2024 in terms of order dated 16/5/2024 passed in the writ petition. The learned counsel for the petitioner has submitted that on account of certain medical issues, the defects could not be removed in time. Counsel for the opposite party has no serious objection to the prayer for restoration. Considering the aforesaid facts and circumstances, the time for removal of defect in WPS number 4368 of 2023 is extended till 11th of July. If the defect in the writ petition is removed within the extended time, office is directed to place the writ petition before the appropriate bench as per roster. This CMP is accordingly disposed.
Item 418, CRMP 368 of 2025.
Yes, for not putting my still not today.
क्या CMP फाइल कर किसने फाइल की?
मुझे बता पाएंगे इसके बाद
Who are you?
I understand.
Counsel for the petition seeks adjournment. Post on 29th August. That is 29th August.
Item 419, contempt suit 451 of 2025.
reason order, Your Lordship.
Lords, in this case, he has taken a new plea that this institution is not recognized by any of the institutions. Although, my Lord, sir, we have got the notification of the Jharkhand Academic Council as well as the Central Government Council. That
Which
this
is this
Priyas Mahila
institution?
Vidyalaya is recognized under the central government as well as the Jharkhand state. So only 2 weeks time may be granted so that I can file a refund reports.
Contempt Civil 451 of 2025, counsel for the parties are present. Counsel for the petitioner prays for and is granted time till 18th of July to file a rejoinder to the show cause.
Okay.
Post on 1st of August.
Item 420, Contempt Civil 462 of 2025.
Your Lordship, as per the last order, we have filed the show cause.
Applied?
No, Your Lordship. As we have stated in paragraph 3, 4 and 5, that there is a several 3 Sanskrit colleges in Jharkhand. But for all the same, we have to take an approval from the finance department to for a pay fixation. For that, we have sent the files to the finance department and waiting for the approval. Thereafter, there will be a cabinet approval. Then we will able to comply this order through letter dispute.
When did you send the
File is before finance department.
When did you send the file to finance department? Why have you not stated? When was the order passed? 24. Why have you not stated? कितना टाइम लगेगा?
So that also query we have made before the department as well. They said that there is after the approval of the finance there is just because there is financial transactions with the cabinet approval is must. So they are also not.
They are functional or non-functional?
The finance department is functional.
Functional है ना? खर्चा पानी चल रहा है ना आप लोग का? सैलरी मिल रहा है सबको? हाँ? इसके बाद कैबिनेट भी है कि वो भी डिफंक्ट हो गया? या अगला इलेक्शन का वेट करें हम लोग? कोई टाइमलाइन है आपके पास? Do you have any timeline?
Also short the same. They said कि after.
कि सब्स्टिट्यूशन फाइल होगा इसका? उनका नहीं आपका. New finance department will come, new cabinet will come after fresh election. Yes? तो कोई टाइमलाइन बताइए भाई. ऑर्डर 24 का है, February 24. काम कराते हैं और पैसा नहीं देते. उसके बाद अप्रूवल चाहिए. क्यों करवाए काम? नहीं करवाना था ना? नहीं करवाना था. कौन है इसमें? और शो कॉज किससे फाइल किया? पूछ के आई उनसे कितने दिन बाद हम इसको रखते हैं. He has to pursue it. राइट, पूछ के आई. 2:15 बजे बताइए कि कितना दिन बाद हम रख दें कि इनको पैसा मिल जाए. जितना दिन बोलेंगे उतना दिन बाद रख देंगे, लेकिन उसके बाद कुछ बताइए, पता करके. तो उसमें टाइमलाइन दिए है, इसमें कितना दिन बाद रखना है? नहीं दिए ना. कब भेजे ये भी नहीं लिखे, वो भी जरा बता दीजिएगा कब भेजे. एफिडेविट फाइल करने के एक दिन पहले.
File has forwarded, then some query has made before the department.
तो कहाँ है वो डिटेल कहाँ है? व्हाट्सएप में ले लीजिएगा क्योंकि ऑर्डर में लिखाएंगे. राइट.
Item 421, Contempt Civil 466 of
They
2025.
have passed the order contrary to the judgment passed by Honorable High Court Lordship. Your Lordship directed the pass the order in the light of LPA order and same benefits has been given to the petitioners.
in promotions matter, they have considering the LPA matter, the clause 3 of the notification has been deleted. The वास्तविक लाभ joining के तिथि से देय होगा, that has been deleted as per the LPA order in the other cases also. In my case, they have passed the separate order and passed the order of recovery. Lordship, can you see my supplementary affidavit?
Where is my order?
Lordship, your Lord's Connection 3, page 22. Paragraph 7 and 8, Lordship. This court find that the issue regarding the promotion of the subject matter concerning the subject of the two persons and court settle and only in judgment by LPA number so and so and follow up the orders by memo number 8 so and so so and so. Respective read petition whereby the clause 3 of the notification number so and so has been deleted. Promotion against the available vacancy has been directed to be given. This court is of the consideration given. आइए उसके बाद उसके ऑर्डर पास
At least we have filed a supplementary source and we have passed order that is at page 14. We have given the promotion to these two petitioners with effect from the date the juniors have been promoted. My lord, considering the judgment of LPA, kindly see page 14 of the supplementary source we have filed.
LPA का judgment पढ़ते हैं ना? बताइए LPA में कहाँ लिखा है from the date the juniors have been promoted देना है? लिखा है इसमें?
No, but my lord's order it is there.
क्लॉज 3 डिलीट किए सब में हम लगाए सप्लीमेंट्री में इसमें भी लगाए सब में क्लॉज 3 डिलीट किए इसमें सेपरेट
Similar benefit to all identically situated persons.
उसमें डिलीट कर दिए क्लॉज 3 और मेरे में सेपरेट ऑर्डर पास किए हैं रिकवरी.
Promotion has been given, but since excess payment was made to them, after calculation, the recovery amount has been paid. But the order, which is at annexure A, has been passed in compliance of the.
They have deleted the clause 3 and thereafter whatever the benefit given to me or deduction that will be done by the respondents. In that they have like finance department has given the other opinion, therefore they have difference with the order.
If my lordship only come to page 14 of our supplementary source, whether the clause 3 has been taken care of or not, it will be clear.
You see, there was a clear finding of the LPA court that the petitioners were also entitled to get the financial benefit with retrospective effect from which they were promoted to the post.
It has been given.
With effect from what date?
Page 15 of the SUPAS. वादिगन श्री प्रमोद प्रसाद सेवानिवृत्त सच एंड सच एवं श्री कामेश्वर सिंह सेवानिवृत्त सच एंड सच को दी गई प्रोन्नति के तिथि तथा तत्समय कामेश्वर सिंह को क्रमशः 1/11/2006 एवं 1/9/2007 के प्रभाव से दी गई with respect to retrospective effect only from the date the others have been given benefit.
क्या लिखा है? नोशनल प्रोन्नति दी गई.
कहाँ लिखा है?
उसी में
पैराग्राफ 5
पेज नंबर बताइए.
पेज 15
पेज नंबर 24 में है. उसके बाद अपने फाइल
हमने सप्लीमेंट्री सोर्स फाइल किया दैट इज पेज 15 जी पैराग्राफ 5 में भी सी
पैराग्राफ 5 आई एम देयर.
मैम वादिगन सच एंड सच को
ये नोशनल प्रोन्नति दी गई है इसका क्या मतलब?
वहाँ डिलीट करते हैं उसके हिसाब से कैलकुलेशन कीजिए.
भाई नोशनल प्रमोशन दिए हैं विद इफेक्ट फ्रॉम द डेट यू हैव गिवन देम प्रमोशन एज पर द एलपी ऑर्डर. तो कहाँ से आपने इनको मॉनेटरी बेनिफिट 1/11/2006 and 1/9/2007 से दिया है.
My lord, NDC that has been calculated. That is the thing that has been calculated.
आपने नोशनल वर्ड क्यों यूज किए हैं?
कैलकुलेशन देख लिया जाएगा. कैलकुलेशन भी लगा दिए हैं उसमें सब डिडक्शन कर दिए.
बताइए कहाँ है आपका कैलकुलेशन?
इसी में लगाया.
आपने सोचा अगर रीड फाइल किए थे अब आप इनको बता
नहीं
अब रिकवरी का ऑर्डर
that is not the case. We have given them
आप हमको ये बताइए आप नोशनल आप प्रमोशन दिए हमको बैकडेट से रिकवरी का ऑर्डर कहाँ से आ गया?
Because the financial benefit has been calculated from the year 2012.
Why?
Therefore, the recovery.
Why? You have given the promotion with effect from 1/11/2006 and 1/9/2007. Why will you give the financial benefit from 2012? On the face of the order in the LPA, it says that financial benefit with retrospective effect from which they were promoted to the post.
But
You
it
are
has been
given
the financial benefit can only be given from the date the vacancies arise.
तो आपने क्यों दिया? वैकेंसी अगर नहीं था 2006 में तो आपने क्यों दिया वैकेंसी का?
नोशनली दे दिया गया।
नोशनली कैसे दे देंगे? वैकेंसी नहीं होगा तो
उसको डिलीट कर दो। उससे पहले वाले पैराग्राफ में अगर देखा जाए, इफ पैराग्राफ 4 में काइंडली
देखिए इतना कहानी हम लोग कंटेंट में नहीं सुनते हैं। आपने उनको नोशनल बेनिफिट दिया है
जी,
प्रमोशन का
जी,
फाइनेंशियल बेनिफिट भी
उसी के से दे दी बस।
यही है एलपीए का ऑर्डर।
बिकॉज उसके पहले बोला गया है हुजूर कि इसमें रिक्त पद जो थे वो 6 रिक्त पद थे, इसीलिए
कब से थे?
दैट वाज इन द ईयर 2012 में।
अगर
तो वैकेंसी
एक सेकंड 2012 में अगर वैकेंसी अराइज होगी तो 2006 में आप कैसे प्रमोशन दे देंगे?
वैकेंसी लगाए मैडम।
आप कैसे दीजिएगा 2006 में प्रमोशन? समझ लीजिए भाई, अपने जो भी आपके आप शोकॉस फाइल किए ना उनसे समझ लीजिए। You have not, you see the case was disposed of in the light of LPA number 57 of 2019. You have to demonstrate how is it in terms of 59 of 27.
One indulgence will be given will be
आपको समझ आया कि बुलाएं किसी को समझाने?
हम
समझ आ गया ना?
ले लेते हैं हुजूर and I'll make sure that on the next day
The learned counsel for the opposite party has submitted that notional promotion has been given to the petitioners with effect from 1/11/2006 and 1/9/2007 respectively, but financial benefit has been given only from 2012 as the vacancy arose only in 2012. He is unable to explain as to how the promotion could have been given from 1/11/2006 and 1/9/2007 when the vacancy arose only in the year 2012. He is also unable to explain as to how the order passed by the authority is in consonance with the order passed in LPA number 57 of 2019 dated 14/11/2019 as the writ petition itself was disposed of in terms of the sender. In LPA number 57 of 2019 there was a clear direction that the writ petitioners were also entitled to get the financial benefits with retrospective effect, which they were. ठीक है? ये नोशनल का झुंझुना लेके क्या करेंगे? किसी काम का नहीं है इनके, और आप रिकवरी का ऑर्डर कर दिए।
2 weeks time
Post on 4th July. The supplementary show cause be filed by 1st of July. ये जो आपका ईगो हैसल चलता है ना, we are quite aware of that. ऐसे नहीं करने का। आदमी बंदा आके रिट पिटीशन फाइल करेगा, आप रिकवरी का ऑर्डर, चोर है कोई, रिकवरी का ऑर्डर कर दिए हैं, वो भी बिना शो कॉज नोटिस के, बिना किसी के, डराते हैं लोगों को। रिट में नहीं आना है, आपके पास नहीं गए, आपका मतलब आपका डिमांड नहीं फुलफिल किए तो रिकवरी का ऑर्डर कर दीजिए, है ना? ऐसे नहीं करने का। और रिकवरी का ऑर्डर ऐसे होता है बिना शो कॉज के। हाँ, जैसे आपके रिकवरी का ऑर्डर बिना शो कॉज के किए हैं, वैसे ही स्टॉपेज ऑफ पे का भी ऑर्डर बिना शो कॉज का। कैसा लगेगा? इट्स अ मैटर ऑफ पेट का सवाल।